All right, I'd like to call to order the Brevard County Charter Review Commission to start up. If we could all rise, please, for the Pledge of Allegiance. And Mr. Nye, why don't you lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, Melissa, if you could please call the roll, that'd be great.
Robin Fisher.
Here.
Kendall Moore. Marcia Newell. Here. Mike Herodopoulos.
Here.
Marie Rogerson. Here. Blaise Tredis.
Here.
Bob White. Present. Matt Nye.
Here.
Gabriel Jenkins.
Here.
Tom Jenkins.
Here.
Cole Oliver.
Here.
Sue Schmidt.
Here.
Jordan Chandler.
Here.
Vic Lubker.
Here.
Dave Newman. We have a quorum.
Thank you very much. All right, first let's get into the approval of minutes. Do I see any objection to approving the minutes? Seeing no objection, we'll mark those as being accepted. What I'd like to do, if we could, I know that the pressing proposal before us today is item G, which is unfinished business. If we could just take a couple minutes to go through the reports, and before we get to the proposals today, we'll get into the unfinished business, which is found in item G. Of course, we're going to take up the motion to change from 10 in Rule 17 to go to 8, and we also have a motion to delete Rule 16 from the Rules of Procedure as well. So we'll take those two votes up before we go down to Section F, which is under proposals to hear the charter cap et al. That follows. So first thing I'd like to do is we've got some reports from staff as far as kind of what's going on. We've had a little of an issue as far as public hearings are concerned that was brought to my attention today. So why don't I turn it over to the staff first, and we'll kind of go through a few of those issues. And anyone has any questions for the staff before we progress, just please let us know. Jim, you want to go ahead?
All right, thank you, Mr. Chair. Members of the commission, as we were going through checking a couple other items with our legal ads, we've discovered in the newspaper that the two previous meetings were not advertised as a public hearing. We spoke with Paul, and Paul's suggestion is, or recommendation is, those were not official public hearings. We had put them on the agendas, we had public speaking, but they were not advertised. That was our mistake. So today's meeting is advertised as a public hearing through the legal notices. So kind of leading up to your guys' decision on the charter, in so many words, says that you have to have 3 public hearings 10 days apart before you transmit any recommendations onto the board. So based off of that, today would be your first public hearing, official public hearing.
All right, questions for the staff on that issue?
I do.
Tom, go ahead.
If I go by what prior charter review commissions have done and what I read in the charter, it says that you require 3 public hearings only for those items being recommended for submittal to the voters. If it doesn't get through this charter review commission, it doesn't require 3 public hearings. So in the past, what we've done is we've heard, discussed, and voted on any amendments. Then we hold 3 public hearings at the end of the process to determine whether they go forward or not.
Okay. Other comments?
I have no thoughts, Mr. Chair.
Who did? Oh, there, Vic. Yeah, Vic, go ahead.
So, Mr. Liesefeld, if that's case to go forward right here, would this be the first meeting for everything now? Would it be basically a clock reset?
Well, I mean, that would be up to the commission to decide, but this is the first properly advertised public hearing that we have.
All right, well, I think I would like to defer to the chair too, since he's got vast parliamentary experience in this area, so I'd like to hear his thoughts.
Sure, well, let me hear everyone else's first, and I will definitely give you my thoughts, I promise. I don't mind giving my opinion. Other opinions before we, please?
Even though there's been public hearings, really, in reality, I think that the public should be heard before our votes on it. If the suggestion is that we vote and then have public hearings, that does not seem correct to me. I think we should just start from scratch.
Can I respond?
Tom, of course.
I don't think anyone's suggesting the public would not have an opportunity to provide as much input as they choose to provide. It simply says, if you read the charter says those items being recommended for submittal to the ballot shall have 3 public hearings. That's what the charter says.
Yeah, I would
Ms. Rogerson, yeah.
second what Blaze said. To me, I agree, by the letter of the law, it's totally correct. But to me, as if I was a member of the public, having seen how we all feel in the discussion process and then having the opportunity to have the public input would bother me. So I'd prefer that we have it as we go.
Other questions or comments?
Just one, Mr. Chairman. I'm inclined to agree. Correct me if I'm wrong, Commissioner Jenkins, but if we debate it and discuss it to the point where we're ready to make the recommendation and then we have 3 public hearings, isn't that going to prolong the process? Isn't that going to add a considerable length of time to the whole process?
Well, I mean, I'm just really repeating what the charter says. And again, I'm not saying that the public cannot speak at every meeting.
Right.
And the public can speak on each and every item, but the public doesn't know what we're going to vote for. Once we decide what does and does not go on the ballot, then they have the opportunity to comment specifically on those items that are going forward, not the ones that are not going forward.
So it would prolong the proceedings.
It could.
Yeah, okay.
Other comments?
Can I follow up on that? So we would still then, the public would still have 3 bites at the apple.
Of course, in every case scenario. But I would say this, if you're asking my opinion, we're going to be here anyway, right? And so in an abundance of caution, why don't we just count this as meeting number 1? I think we all know we're going to vote on most of these items anyway. The bigger question might be need 8 votes or 10. Maybe that's a bigger question for today, let alone the future. But I think in an abundance of caution, we have enough scheduled meetings. I don't think we're going to see an avalanche of new proposals. So in a worst case scenario, I think we're up number 9, I think, for number of proposals. I think a few of them might be clunkers anyway that might not get the support right off the bat. That said, I think we're going to be here, and what I think we might want to do today is make sure everyone knows the rules. That means, do you need 8 votes or 10? We'll decide that today. And if there's another adjustment in the rules, and then there'll be 2 more public meetings. And I would imagine, 2 meetings from now, we'll have that first vote on just about all these items if we want to. I'd like to stay away, as Commissioner Moore talked about, from the vote-a-rama. So maybe we decide how we want to break that up. And I think we'll also see, as we go through each of these proposals in each of the next 2 meetings following this one, which have viability. I think some of these, based on the comments that were made from our last meeting, some of them might not have that threshold, whether it be 8 or 10. So I would, if it's okay with the members of the commission, I think we're kind of in agreement here that we wait, an abundance of caution, and wait for those votes to take place 2 meetings from now so that the full public hearing could be had. And I think as we're getting closer to the end, just like in an election, people are paying more attention. So I'm sure by next meeting we'll have this room filled and everyone can kind of have their say. But it's nice to see some familiar faces here too. So if that's okay with everyone, for a motion, Mr. Nye?
Yeah, I'll move that we do as the chairman just suggested. I move that we reset the clock to make this the first meeting in terms of public hearings.
Without objection, show that adopted. Thanks so much for everyone working on that proposal, and I'm glad you caught that now and not later.
Sorry, we're sorry for that.
Also, as a public announcement, May 12th is the last day if you want to get a proposal in. That's our next meeting. That is the last day you can get a new proposal in order to meet this time crunch that we're putting on there. The good news is you're not that far behind the people who are online already. So any other comments on that? All right, let's move to the next issue. I'm sorry, Tim.
I'm sorry, Mr.
Sure.
Chair, I do have one more. I'm asking if I can get a little clarification. Last meeting, the commission asked for the costs of an election, district versus whole. I spoke to the supervisor of election office. I can just get a little bit more detail on what are you all looking at. You know, they explained, you could have a referendum, which it could be a mail-in, or you could have by vote. So I didn't have the full information to give everything for the supervisor. I didn't want to take a supposition, so I was asking to at least bring it back. If you still want the cost of an election, exactly kind of what you're looking for. And that would help us to get you the right number.
All right. I know a lot of people have vested interest in a very important issue. Questions for the staff as far as what direction you'd like to follow as far as giving that kind of information to the supervisor elections so they can give us a clear idea of how much that election would cost. Anybody have any specific questions or direction that you'd like to give or as we kind of discuss this?
Yes, my suggestion would be that it's a regular in-person election. That cost.
And then to clarify further, by district and countywide, correct?
Both.
Okay.
Thank you.
All right. Anyone object to that? I think that's the very smart proposal. I think people are going to want a typical election, and so we'll break down by the district. And I think, given the interest in this, a lot of people have talked about it exclusively for school board, and this could, at some point, be other positions. But I guess you're just going to have to break it down one by school board, and then a member, that was 5 members, and then also countywide. Correct? Okay.
Thank you.
Any other clarifications on that issue? All right. Okay, CRC staff also has the issue now, of course, on the cost of the 3-member attorney panel.
Yeah, sorry. Yes, Mr. Chair, you all asked for what the cost was from the last time. 2016, the commission didn't have any recommendations passed on the board, so there's no 3-panel. So we went back to 2010, and the information's in there. Charges went from $165 an hour to $225, and then we put the invoices behind so you can see the various time that the 3 different attorneys spent on the items, and there was 4 items that they were reviewing at the time.
Okay, any questions on that item as far as the costs? Okay, seeing none, let's go to that second section, the history of the 3-member panel.
And that, we were asked on how that came about. That memo's in there. What you have in there is the 2 resolutions by the Board of County Commissioners. It was done, I don't know how to put it best, in between charter review commissions. The county commissioners can put items up to vote for the charter, and that's what happened on both of those. One was done for when citizens submit petitions, and then there was another one when the Charter Review Commission submits a petition. So that's how the attorney panel came into being.
Okay, any questions on that? Blaze, do you have any questions on that?
No, sir.
Okay. All right, that information is there for your reading pleasure. And again, as we move forward, feel free to comment on that in future meetings. All right, next let's get into kind of the more legal issues on the time for recall. If you want to get in there, Ms. Goldman.
Sure, Mr. Chairman, I'm not going to belabor this. You all have my memo, but Commissioner Oliver had asked for what the timeline is for recall elections, and I've tried to lay that out as best I can by following the statute. Unfortunately, the Supervisor of Elections Office wasn't able to help because since Ms. Scott has been our Supervisor of Elections, she advises that they have never had a recall election, so which is interesting. I'll be happy to answer any questions on that.
Other questions?
I
Please.
have a comment, and by my math, you add up all the dates, it's between 195 and 225 days. Your short answer is 225 plus days. My math is 195 to 225.
Mm-hmm.
And the 30-day difference is because of election within 30 to 60 days at the end.
Mr. Goodwin, you see it the same way?
Sure.
Okay.
The next memo is whether or not the county commission can reword a proposal by the Charter Review Commission. The answer that I find is I don't believe that they can. And I lay out what the reasoning for that is based on not only the wording of the charter, but how these proposals, after they leave here, they have to go to the 3-member attorney review panel, and then they go to basically to the commission, county commission, with the idea of that point of being placed on the ballot.
Please.
My concern is this. With my proposals, as with bills in the legislature and constitutional amendments, additional words or underlined, deleted words are stricken through. So that's what my proposals are. I think that's correct. The concern is that many of these proposals are really not in proposal form like that. They're ideas, I would say, which are general ideas. And if any one of those generally worded proposals were to be passed by this commission, then someone is going to have to come up with the language that goes before the voters. And I will just say that I would not vote for any proposal that is a general idea for that reason. It needs to be precise. When bills go to the legislature, they're, just as I said, same when the voters get to vote on a constitutional amendment, just as I said, underlines and deletions to the existing wording. So I want to point that out. And that's my recommendation to the board would be to do the same. If there's a proposal that adds to the, changes the charter, that if it's not in the form of underlined for additions and stricken through for deletions, that's a reason, a good reason to vote against it.
Mr. Chairman, I would absolutely concur with that. In doing research on some of these questions in the past, I found that underlining and strike through, which is pretty standard for this type of thing, have not been used in the past for whatever reason. And as a result, it's somewhat unclear what language is being changed, how it's being changed, what the context of it is. And I think it's important. That's part of figuring out if anybody needs to interpret at a later time what's been done, that's part of how you figure out what the legislative intent is. So I concur with Mr. Tredis. I think he's right on. And I think the other question that he's started to broach is the wording on the ballot question. And in the past, I don't know how this has been done by this county, but somebody needs to construct that ballot language. There are fairly specific rules that are statutory rules for how you construct that ballot language, but there's still an art to it, if you will.
Please.
Are you talking, Mr. Googleman, about the summary language?
The ballot summary, yes.
All I can say is I guess I will file amendments, since there's now more time, to these proposals on mine that will include summary ballot language. I don't see why this commission should not be able to vote on it. The concern with this commission voting on it identically how it's going to show up on the ballot is if you don't do that, you're letting someone else write it. When they write it, well, that's not what we voted for. So that's why it's just, I think, of utmost importance.
The ballot language question is something that applies to things such as state constitutional amendments, and there have been a number of cases where proposals have been submitted to amend the state constitution, and based on the ballot language, the Florida Supreme Court has basically invalidated those issues because they are, as the court says, misleading to the voters. So there's definitely an art to drafting those ballot questions, and of course they cannot be over 75 words by statute.
Stratus?
I'd just like to point out in reading, I think it was in Mr. Googleman's memorandum on the three-attorney panel, I believe that attached was the ballot language, and it was interesting that three attorneys were not mentioned. In my recollection, it said an independent review panel, but it didn't tell the voters that it would be a three-attorney panel, which I thought was terribly wrong.
Other comments? Mr. White?
Well, that was going to be my question, was going to be who exactly is going to do that for us. In Tallahassee, we have bill drafting in both chambers to take care of that issue. And to my knowledge, we don't have an office of bill drafting. So I'm wondering who exactly is going to be tasked with that responsibility.
Well, I think I probably defer to Mr. Googleman and his team, and of course, we would review that in subsequent meetings and vote, in essence, to make sure that's the language you want, or at least work together, just like we would in the committee process in the legislature, to get that language that we're all comfortable with, 75 words are less. And I think Mr. Trez's point is well taken, where in our state, you underline or delete, and it's clear to the voter in the legislature, let alone people across the state, of what's been changed. Unfortunately, Washington doesn't do that, but that's another
Right.
story.
Yeah.
Right.
I know Congressman actually Posey's working on that. But that said, I think it's a no-brainer, and I think as we have a lot more time now to have a final vote in these measures, that as you get a sense of which ones will make it to the ballot, that be thinking about the ballot language, and maybe we can even devote even more time to future meetings to make sure that our intent is clear.
Okay.
I think that'd be very helpful for everyone, whatever should make the ballot.
Mr. Chairman, then if we can move on, to item 3C, who may contest a finding of the three?
One second, I think, Mr. Schmidt, you have a question?
Yes, I had
Oh, I'm
a
sorry.
question for Ms. Dugelman.
I'm sorry.
As far as what you responded to the question, and that was as far as rewording from the commission, it's my understanding, according to the charter, that no matter what the county commission gets, they can't reword it, but what they can do is not determine or decide to send it on. Is that correct?
The short answer is a somewhat equivocating yes. And the reason is because the concept of not being able to reword and at the same time being able to keep something off the ballot if it is determined to be unconstitutional or inconsistent with Florida law. That comes from an opinion of the Brevard Circuit Court back in the year 2000. And in that particular case, it wasn't a recommendation from the Charter Review Commission. It was a referendum petition that had actually been submitted to the county, and the county commissioners were looking at rewording it, trying to clarify it. And anyway, the case went to the circuit court, and they said, no, you can't reword it. However, if it's determined to be unconstitutional under the Florida Constitution or inconsistent with Florida law, you can elect not to put it on the ballot. And if you follow that concept, it probably holds true for recommendations that come from the Charter Review Commission.
Thank you.
And I will tell you that that's kind of where we get to this issue of the three-attorney review panel. And as Mr. Tredis has noted, it's a panel that seemingly has a lot of power.
All right, so we're on that item you brought up on 3C, who may contest the finding of a three-member
Yes.
panel. Please go ahead.
Yeah, and the short answer to it is that obviously the county commission could contest it. It's likely that the Charter Review Commission would be able to contest it, except for a couple of problems. Number one is when this group was set up, it has a limited duration, and it also has to have funding to go ahead for undertaking any sort of lawsuit. So that could throw some roadblocks in the way. With regard to individuals, such as somebody that has actually proposed an amendment here, not a member of this commission, but a member of the public, that person has an argument for what's known as standing, in other words, the right to go forward with a lawsuit. Whether or not a court would say that that's sufficient, I think is somewhat open to question, but you can make a good argument for that. And then last but not least, if it's some general member of the public, again, to have standing, a general member of the public couldn't just go out and file a lawsuit. They would probably have to have what's known as a special injury, which means that they are affected to a much higher degree or in a much different way than the public at large. So,
Well, let me get
confusing, but I hope it answers your
Yeah, let
question.
me get into that for a second then. Obviously, the group that would have standing would be county commissioners.
Yes.
And so if one of our county commissioners chose to challenge that three-member panel, they would have standing, and of course, they have budget dollars to make that request. Would that be an option?
It is an option. There's also another approach, too, that they could follow if they elect to, and this gets into sort of the politics of decision-making, and that is that, of course, the county commission has the ability to propose its own amendment. And so you could actually have a CRC proposal followed by a county commission proposal, and I haven't researched it, but I think under some rules of law that I seem to recall from some years ago, if the county commission's proposal comes second in time, that would be the one that would probably prevail in the event of any inconsistency.
And on that same notion, if the county commission proposes one of these charter, do they have a three-member panel overlooking them?
Yes.
Okay. Mr. Tredice, do you have a question?
Well, it was, yeah, a comment and a question. I think is it true, Mr. Gugelman, that even though by the charter wording, our work ends at the vote for proposals, the contract that Brevard County has signed for us, for you to do your work, does not have that limitation. So therefore, there's a very, very strong argument that we could use your services to make that challenge.
Theoretically, but again, would have to be funded. And, as anything in the legislative arena, he who has the gold makes the rules ultimately in the end. And so.
Or you could do it pro bono.
Thank you. Next item.
Got it, okay. All right, the last part is control of school board agenda items.
Yes, this was a question by Commissioner Newman, and I've tried to summarize some of the statutes that are pretty specific as far as how school boards in Florida are supposed to operate, and my conclusion is that we probably couldn't get into that amount of minutia.
Okay, thank you. Okay, we've completed all the reports. Are any other questions for staff before we get into section G, dealing with unfinished business?
Mr. Chair, I do.
I'm sorry, go ahead.
This is actually a question for Paul. Going forward, it's kind of a homework assignment, if you will. Since we're on a deadline for any new potential proposals, can I ask you to look into the charter, section 5.2, as it relates to recall, and then specifically what it references as members that can be recalled in section 4.2. There's a lot of information flowing around out there right now, and
I can give you kind of a summary on that. I'd be happy to write you all a memo on it to summarize it so everybody knows what we're talking about.
Okay.
Otherwise, it's going to sound kind of like Greek. But where you're running into a problem is that somewhere along the line, back around 1998 or 2000 or whatever, we had another one of these amendments go through that didn't have the strike through and underscore and wasn't complete. And as a result, I think it was section 4.2 in the charter, should have gotten changed, but it didn't. It didn't get changed. So it now is an erroneous reference. But I'll be happy to write that to you.
so are you saying the disconnect is that what 5.2 is saying, that those individuals identified in 4.2, and for those that don't know, we're talking about our constitutional officers,
What it
are
means.
subject to recall or not?
Yeah, it means county commissioners is what it means. If you research it all the way back in time, it means the county commissioners are subject, but to recall. But somewhere along the line, when they were amending sections, the numbering got messed up.
So to clarify that, a proposal would potentially clarify that, or add them to the potential list of individuals subject to recall.
Clarifying it probably might be the best approach. There's one other thing too, if I can
Absolutely.
backtrack, Mr. Chairman. I had forgotten when we were talking about who can challenge the charter and can the county commission reword a proposal. I think it's important to note that in the charter, with regard to the three-member review panel, attorney review panel, it talks about if the panel says something is constitutional or consistent with general law, then it's supposed to go on the ballot. But what the charter does not say is if that panel rules that it's not constitutional or not consistent with general law, what happens? And that's one thing in the charter that's completely unclear. So if you have a chance, go back and look at my memo again. And one of those two memos is where it points out that that could be somewhat problematic. Again, we've had time to amend this charter several times, not this body, but the charter review commissions of the past, and what's happened is that we're now starting to have a little bit of a word collision.
Okay.
Are you okay trying to meet maybe a May 2nd deadline with an official opinion, so that way I have time to
Sure.
make a decision how to move forward?
Yes.
All right, I appreciate that.
Mr. Chairman, I would call somebody, maybe the legislature, I don't remember who, passed something in the last year or two that said the sheriff, supervisor of elections, et cetera, were constitutional officers in
Yes.
Charter County. That's not in here, is it?
Mr. Chairman, that was adopted, I think, by the voters in 2018. And there has been, over the years with these charters, there are a number of stakeholders and people that have significant interests in these charters, and that are sometimes competing with what a charter commission may write in the charter. And the people that are most affected by this are your so-called constitutional officers, the property appraiser, the supervisor of elections, clerk of the court, and tax collector. And the reason why they are most affected is because some charters have either decided to try to eliminate their position. For example, in the Broward County Charter, the position of tax collector as an elected office was done away with. And the person now is what they call the revenue collector, who's appointed by the county administrator. And it's not even an elected office. In other cases, there have been some charters that have decided to move the responsibilities around from one constitutional officer to another constitutional officer, probably under the idea of making things more efficient. But the constitutional officers many times in this state take that personally, and as far as being able to perform their job properly, and therefore they have a strong lobby in that regard. And I will tell you that when the original charter here was drafted, the then property appraiser was very active and very vocal about what should or should not be in the charter. And it's just the way it is. It's the nature of how things are set up.
Mr. Chairman, I also think one of the intentions of that being adopted deals with the budgets of the constitutional officers, and they are now protected by state regulations, state process, as opposed to any kind of local process. And I think that was one of the biggest things they were looking for. was to be independent of the county commission to the extent they could be.
Mr. Chair, I want to be clear on this too. Paul, so you understand my thinking. I'm strictly looking at this from the perspective of state statute for recall with regards to malfeasance, not showing up and doing your job, a felony. As a Brevard County constitutional officer, would you be subject to the same rules based on what I said about 5.2 relative to 4.2? As far as funding and all that, Tom, totally agree. That's state level. I'm talking about the process of recall related to how malfeasance and those things work, how that sausage is made.
We'll try to get something to you, and perhaps in the next week or so.
All right, thank you.
Thank you. Other comments? Okay, let's move over to Section G, unfinished business. And we're going to look at one proposal at a time. The question on the table for us is the first one by Mr. Tredis, which is the motion to change from 10 in Rule 17 Charter Amendments to 8. Before we get into voting, I think we're on debate at this point. And for those people who'd like to debate, just raise your hand and we'll just go through there before we call. And I'm not going to vote, ask for the yeas and nays. I'm going to ask for a roll call vote, just so you're all aware of it. So why don't we start in debate? Whoever would like to get started, and we'll just, whoever would like to speak would be great.
I have a question.
Sure.
I received an email, and I suspect everyone else did, from a gentleman named Dale Davis, I believe it was. Did everybody else get that email? Mm-hmm. And in that email, he was saying that Robert's Rules of Order suggests that it takes a 2/3 vote to amend operating rules, and I just wanted to ask Mr. Gugelman if that...
I think that's correct. That's pretty much the standard. Robert's Rules of Order would say 2/3. However, your rules specifically, which supersede Robert's, your rules specifically say that you can amend it with the affirmative vote of 8 members. So you have a different standard, and in my view, that's probably legal.
And I think, and the effect of that, Mr. Jacobs, is a good question, is whoever this vote goes, it'll probably decide which goes. So, I mean, you can make a motion right now to say, I want to make it 9 or 11 or 12 and to see if you can get 8 votes, right? So we'll go from there. In debate, anyone? Okay, Mr. Tredis, in debate.
I'll just repeat what I think I said last time briefly, which is Brevard County would be in the minority to require this supermajority out of the 19 charter counties in Florida. I counted 4 that have a 2/3 vote requirement to pass recommendations, so we're in the minority. Also, the point is that only 8 is a quorum, and you could have a quorum of 8 and not possibly pass any proposal because there wouldn't be the required 10 to pass any proposal. And the third thing is simply that majority, I think, should rule. And also, this is just to get the proposal to the voters, and the voters have the ultimate decision. So for those reasons, I submit that Rule 17 should be changed from 10 to 8 votes required to pass a charter proposal.
Okay. And before we get there, I think we have a Mr. Stan Johnston here who would like to come testify. Mr. Johnston, come on. We'll give you a couple minutes to present.
Mr. Chair, I'm also going to jump in as well.
Okay. Yeah, I'm going to keep the thing going after this. Go ahead, sir, please.
My name is Stan Johnston. I live in Titusville, 860 Poinsettia Avenue. I'm a registered professional engineer. I came today and I heard that the meetings were not announced, that it's out of the sunshine, and I don't understand how in the world you could be starting with G when there's F and so forth. When you violate the sunshine law, all those meetings that you had, those 3 meetings you had, are null and void. You can check with Mr. Gugelman on that. They're null and void. So why in the world are you starting with G when you should be doing the other agenda items? So you're out of, I see that it appears to me that you're out of order. And what I want is I'm giving Mr. Gugelman, this is my name, address, and phone number. I want a letter from your attorney. I want a letter saying that those previous meetings you have, all the business you did was out of law, was out of the sunshine. I want you to understand this. When you're out of the sunshine, you're illegal. All those meetings that you had were illegal, they're null and void, and everything has to be redone. Now, I'm going to ask you to ask him to confirm that. If he doesn't, you're in trouble. You're probably going to get sued. So, stand up and respond,
Thanks,
please.
Mr. Johnson, appreciate that.
Okay.
With that in mind, I think you might have missed the earlier discussion. We basically agree with you. And that's the idea that this is meeting number 1 for all the proposals. And, hey, you win. Congratulations.
Okay,
Thank you.
Thank you.
Yeah, thank you.
Forgot it. You're not going in order, though.
Okay, well, that's the right of the chair. All right, so,
Mr. Chairman?
Mr. Libaker, yeah.
He's coming.
I'm going to play the devil's advocate here. We had a reason why we had the rules discussion very early on in this process. And I'm not a fan of changing the rules midstream because of public perception and how that works. So from my perspective, I'm not, if you did this, and you could probably tell me better, obviously, if you did this in Tallahassee halfway through the legislative process, I think you see a lot of people screaming bloody murder about maybe, I'm not saying we're doing that here, vote counting and all that, and we're trying to line stuff up. I think the rule is the rule, and what we agreed to is what we agreed to. That's kind of where I'm at.
Other people, I heard.
Mr. Chairman, I was just going to, poke the bear for the sake of it. I agree that we press rewind, and since I wasn't happy with the fact that we changed it from 10 to 8, if we went back and started over again on everything, I wouldn't be very upset.
Okay, great.
Comment.
You already had other opportunities before we get there. Other people want to speak on it. I don't think we have a card on that. All right, I'm going to, before Mr. Tredis closes, I think everyone heard my comments from before. We're talking about in essence, the constitution of the county. There are some issues that I really want to get passed, and I'd love to see out of 8. And there are ones that I don't want to see passed, and I'd love to have at 10. So I'm just going to go from my own history, and that is, as I mentioned to Mr. Moore last time, I think a minimum of 9, and if I have a choice between 8 and 10, I'm going to pick 10, because I think this is a very serious document, and kind of beware of what you pass, because you might be in the right team this year and the wrong team 4 years from now. So I'd like to keep it at 10, and the proposals that we like, I will have strong support sending out to the public. The ones that maybe have 8 or 9 votes would be a little different, but I'm going to stick with the 10, because I think, as Ms. Lubiker said, had we kind of seen this change coming along, it'd be different. I believe we're a republic, not just a simple democracy, and I like the idea when we set kind of guidelines, especially when we started this process, regardless of the last concerns that were brought up. I think 10 is a good number, and I know, for example, on the first one, I'm going to vote yes. I'm telegraphing my vote on the charter issue. I might win or lose, but I want to be consistent with what I did in my past life, and I think the 60% threshold is a minimum in my book. And whoever you all chose to vote, I will, of course, back that standing, whether it be 8 or 10.
Mr. Chairman?
Yes. I'm sorry, Mr. White.
Yeah, I was going to stay quiet and just let the vote be taken, but I've just got to say that I think a majority is enough, because we're passing it on to the public, and they're the ultimate decider, not us. So, and the idea that the public is going to be swayed one way or the other because 10 of us voted for it versus 8 of us voting for it, I don't think that really holds any water. I don't even think they're going to know that was the case, quite frankly. So I'm all in favor of them saying, okay, this is coming to me from the Charter Review Commission. They've debated it. I mean, that's all they really, I think, care about when they see it on the ballot in front of them. And so I'm all for getting as many of these proposals to the public as possible. And as far as I'm concerned, 8 is great.
Okay, thanks, Mr. Jenkins.
Are you open to motions?
Of course.
I'll move that we leave the charter language as it is.
I'll second that.
I see, just as a point of order, I see Blaze about to come out of his seat down there. I think there's actually, and everybody's really clear where I am on this, but I think there's a motion actually on the table that was tabled from the prior meeting.
You
And so
are
there is
right.
a live and living motion from Mr. Tredis.
agree.
Yes.
Mr. Tredis, I disagree with you, but procedurally on this one, you're right.
You're right.
I agree. And that's what I said at the beginning. Regardless of how you vote today, it's going to be a 10 or 8. It's kind of a jump ball. So I mean, the vote's going to be the same, I think, whether you go either direction. That said, anybody else besides the sponsor of the idea? You'll go last, Ms. Tress, don't worry. Others? Okay, Ms. Tress, you're welcome. Mr. Fisher? Okay.
I'm at 10, so.
Okay. Ms. Tress, you're welcome to close on your idea.
Thank you. Regarding the argument that it's a attempted change of rules while in progress, my recollection is that the vote by this commission on rules and amendments to rules was either the first or second meeting. And there was no time to really consider at that point in time, the impact of these matters, and to look at the charter in depth to see what needs to be changed, what doesn't need to be changed. So, it was way too early on in the process to, I think, use that as a strike against making any change later, either the first or second vote. And secondly, regarding the importance of the charter, yeah, it's important, but it's also important to remember that serious problems with the charter shouldn't have such a high hurdle to pass to be changed. And what I'm referring to in particular is Article 8, School Board of Brevard County. Florida statutes do not provide any charter review commission authority to insert the creation of single residential districts into a county charter. By state law, it can only happen by two ways: a vote of the school board that goes to the public in a vote, or by a petition of the people that goes to a vote. So what we have in Article 8, I submit, is an unlawful Article 8 school board district in the charter, and it shouldn't take 10 votes to remove what I submit is an unlawful part of the charter. And for that reason, you shouldn't have such a high burden of 10 votes. That's all. Thank you.
Mr. Chairman,
Ms. Schmidt?
I would recommend that we have a roll call
Yeah, I
vote,
did. Yeah, I did.
please. Thank you.
And let me just make sure everyone understands too. I think Brady's brought up, or Ms. Tress brought up a good point. If the county commission saw a serious flaw within the charter, they have the ability to place it on the ballot as well. Is that correct, Mr. Kugelman?
They can always sponsor their own amendment without even going through the CRC.
Okay, thank you. All right, what we're going to do is a roll call vote, and all those in favor of Mr. Tredis' idea to go from 10 to 8 vote yes. All those who are opposed to it vote no. Yes.
You're going to go by name, by district.
I don't care with the order. I'm just saying, make sure if you're for Mr. Tredis' idea to go from 10 to 8, vote yes. If you're against the idea to go from 10 to 8, you vote no. And we'll just go whatever order you have, I guess, whatever you have in front of you. I don't really care. Yeah.
Robin Fisher?
No.
Kendall Moore?
No.
Marcia Newell?
No.
Mike Herodopoulos?
No.
Marie Rogerson?
No.
Blaze Tredis?
Yes.
Bob White?
Yes.
Matt Nye?
Yes.
Gabriel Jenkins Kirstein?
No.
Tom Jenkins?
No.
Cole Oliver?
No.
Sue Schmidt?
No.
Jordan Chandler?
No.
Vic Lubker?
No.
Dave Newman?
Yes.
I have it as 11 to 4?
Yes.
Okay.
Yes.
All right, by your vote, we're going to keep the rules at 10 and not move to 8. All right, the next motion is also by Mr. Tredis. It is motion to delete from Rule 16 of the Rules of Procedure, Brevard County Charter Review Commission, the words with the following strike-through. Rule 16, rule amendments, these rules and policies shall be the bylaws of the commission and may be amended by the affirmative vote of 8 of the members of the commission, with it, and then striking out, with at least one member appointed by each commission present. Mr. Tredis, do you want to proceed with this or not?
Yes, sir.
Okay, please go ahead.
The motion is made because there shouldn't be a residence requirement for passage of votes. As a matter of fact, I think when we, at that first or second meeting, when the rules of procedure were changed, we voted to eliminate residence requirements by district in the rules, but this was left in, probably an oversight. And for the second reason is that it really makes no sense to require the presence of a commissioner from each district. That would mean that for District 1 example, we need someone there who votes no. Only one person from District 1 is here, and they have to vote, or let's say they vote no. Well, no votes don't matter. Only yes votes can pass a matter. So no votes don't matter. So logically, it makes no sense to require that a district have a person there to vote no, if they decide to vote no. So logically, it makes no sense, and we've already eliminated the residence requirements in the other parts of the procedural rules where they existed. So this is just consistent with what we've already done. That's all. Thank you.
Thank you. Questions for the sponsor? Debate on the issue. Mr. Libiger?
Question for the sponsor.
Sure.
So would you change, if you did this motion, would you change it from 8 to 10 based on the previous vote? Just it would take 10 from wherever among us?
I'm not changing that.
How would that work if it's?
It's 8 now. My motion does not change that
For
from
a
8 to
quorum?
10.
Is it for a vote? Or am I misunderstanding?
It only takes 8 votes to change the procedural rules, and that remains under my motion.
And clarify, if you could, how do you view it that way, Mr. Travis? Guess we just had the vote on the 10. I mean, you're talking about the final vote, correct?
No, these are for the rules and policies that Rule 16 applies to. It was changed from 10 to 8 at our first or second meeting. That passed. My motion from 10 to 8 passed, so that's what we have now. And now I only seek to eliminate this residence requirement for the reasons I've already said.
And the reason I'm asking you is I think we know where the vote totals are. It was 11-4 vote. And I would be open, I'm not sure about other members, to eliminate that idea. I like the idea we are one county.
Right.
And I think that you'd maybe even find support here from folks who would say you don't have to have a yes vote from all 5 of the quote commission appointees. So maybe you want to amend that and say in the final passage or what have you, that you don't have to have each one appointee from each of the 5 to move forward, if you understand what I'm saying.
That's what my motion does.
Well,
Exactly.
but you're saying right now is you're dealing with just the internal rules. I'm talking about the final vote. When the final vote, you're okay with just having, is there any requirement that a person from every one of the 5 districts vote yes in the final vote, Mr. Goldman?
No.
So do you really want this rule since we're already kind of along our way or not?
I want my motion to be voted on.
Okay, sure. All right, any other questions?
Mr. Chairman, I
Mr. Moore.
think I brought this up before when we were talking about the prior issue. Yes, we are one county, but there's a significant amount of geographic diversity where issues that exist in Titusville may not exist in Palm Bay, and any given amendment to this charter may not equally impact every geographic area of this county. I would argue to you, it's not split by 3, it's split by 6. North, Central, South, mainland, beachside, barrier island, all very distinctly different in a variety of ways. And I think what this intends to do is to make sure that someone from that geographic area was here and present. I lodged my concern when we changed it previously and have the same concern here, and I would vote no on this motion.
All right, others? Mr. Newman?
And just some clarifying questions. I guess I'll ask Mr. Googleman just so I make sure that I'm tracking, I guess, properly, and for the folks at home too, because it seems very minutia. So my understanding of Rule 16 is that you need to have one commissioner from each district to vote on a rules change. That's what he's referring to, correct?
I think, yes.
Okay. So when it comes to an amendment, do we need one commissioner from each district?
This relates only to amending these rules. Okay?
Right.
And now, if you're talking about a charter amendment,
Correct.
you do not need to have one member from each district
Okay.
to vote in favor of that. This is strictly related to amending the rules.
Okay. And then, so from my understanding, if this is just the rules and we've just gone over that, do we, like, I'm just making sure I ask my question correctly. So in regards, though, to an amendment, just for the sake of discussion, do you need to have one member from each district to pass this board for that?
For a rule
For,
amendment?
for a amendment, for one of proposal on the charter cap or something like that?
Oh, no.
No, okay. So then this is just for rules, which, from my understanding, I think we're past our rules discussions for the most part.
Yeah, I would just say this. I think you're asking a good question. I think, to Mr. Moore's point,
Yeah.
I respectfully just take a different stand. I think that when you talk about the rules, I want to be consistent as far as that whether it be 60% or 2/3 majority. And just like if Delaware is not in agreement with the 50 states, I'm okay with this rule request from Mr. Tredis, but again, it's the will of the commission, whatever's best in your perspective. Other debate? All right, why don't we go ahead and do a roll call on this to avoid the yeas and nays, Mr. Fisher? We have Mr. Burns. Did you want to come and speak on this?
Thank you, Mr. Chair. I wanted to get this in before we got to the proposals. And it's, I agree with Mr. Tredis with the bill, or the proposal should be in a final format, whether it's strike through or underline. And he made the comment that the proposals are coming forward in a summary manner. Well, the reason for that, as someone who's submitted a proposal from the public, there's only one form on the Charter Review website for submitting proposals. And there's no instructions, there's just a blank form. And what it asks for on that form is summary, explanation, and background. And that's all that it asks for. So the reason that you're getting a summary presented is because that's what the form calls for.
Sure.
If it had requested ballot language, I think that, some people are more than capable of presenting that, but it doesn't ask for that. So I think as a member of the public, we would assume that once we bring forward the summary and the idea, that it's either going to be workshopped through this commission or through some kind of mechanism to come up with the ballot language. So it was a little alarming when I heard that we wouldn't vote on something for approval if it's not in that ballot language when it's never been requested, for
I think
proposals.
I think it's a good point, Mr. Burns. And I think that I'm not sure if you heard the earlier discussion, but those proposals that have legs, I think we're going to work as a group to get the language correctly in the 75 words or less, et cetera, format, and make sure that whether it be yourself or others who are
Right.
sponsors are in agreement with that language,
Right.
or at least made aware of the potential changes that the group wanted to make.
Gotcha.
It's one person to propose it. In the end, we get to dispose it if we
Right.
want to. So I think without question, we'll use our expertise, whether it be our legal team or others, to make sure the language is in accordance with, we think, the Constitution and the legality necessary to get on the ballot and give the voters a yea or nay vote.
Thank you, I appreciate it.
Thank you.
Mr. Chairman, if I, over here.
Okay, Ms. White.
Well, if I may, and I'm sure this will come as no surprise to my fellow commission members, but I'm a little confused. So I'd like to kind of clarify this. What we're about to vote on has nothing to do with what we're sending to the public.
Correct.
This is only how we operate as a group.
That's correct.
And presently, it seems that if there's not someone, a member of the commission, that's been appointed by all 5 of the commissioners here present, then we can't amend the rules under the language that I'm seeing here, right? We can't even take a vote because there's not one of us from all 5 of the districts present.
Yes, but I think you see that correctly.
Okay, that's all I needed to know.
Yeah, and I think what's on the floor right now is, Mr. Tredis' proposal is on the rules, not what we're going to send to the public, is there's 5 different districts. Each district got 3 appointees. If in all 5 districts you do not get at least one affirmative vote, that rule cannot be changed. So as I mentioned to you, I support Mr. Tredis' idea, even though there are differences in our county that on a rule change that you do not need at least one vote from the 5 commissions, that's all I'm saying.
Okay.
So further debate on that. All right, why don't we do a roll call? If you agree with Mr. Tredis's idea that you do not need all 5 county commission appointees, one of them, for a rule change, vote yes if you agree with this. If you don't, vote no. And if you could please call the roll.
Robin Fisher,
I'm sorry, Mr.
No.
Kendall Moore,
No.
Marcia Newell,
No.
Mike Herodopoulos,
Yes.
Marie Rogerson,
Yes.
Blaze Tredis,
Yes.
Bob White,
Yes.
Matt Nye,
Yes.
Gabriel Jenkins Kirstein.
It's Jacobs, but yes,
Oh, I'm so sorry.
it's okay.
Tom Jenkins,
No.
Cole Oliver,
Yes.
Sue Schmidt,
No.
Jordan Chandler,
No.
Vic Lubker,
Yes.
and Dave Newman.
Yes.
All right, I've got a 9-6 vote.
Yes.
Okay.
Yes.
So the rules have been changed.
Yes.
Okay. Congratulations, Mr. Tredis.
Yay.
Okay. Okay. On the final item on G, before we get back to the proposals, we're on future meeting schedule. It's under G3 in your packet. And just want to make sure everyone is aware of the dates that are now in play as we look to conclude in August of this year. And again, clear to the public, and as everyone recognizes now, that if you want a proposal, make sure you have submitted it to our staff before the 12th of May so that we can put it on the agenda and give you that opportunity to have 3 public hearings. And as also, if you were not here earlier, the situation is that in an abundance of caution, we are literally in our first public meeting, not our third, and so we'll not have a vote on some of these proposals for a few meetings from now. And again, we have plenty of time to do that. I'm glad everyone agreed with that motion. So our agenda is now set. Again, if you have any concerns about that, please let the staff know. Everyone's been very good about responding to potential meetings, but hopefully with these meetings being announced early and publicly, et cetera, that we're all in good standing. So just want to make sure everyone is well aware of that meeting schedule. And if you cannot make it, of course, please let the staff know with that in mind. Any other questions on the schedule? Okay. All right, let's head back to section F under proposals. We have the charter cap, which is public hearing now number 1. And that is by Mr. Tredis. I think everyone's well aware of that. Are there any questions for Mr. Tredis on number 1 before we take public comment? Okay, let's have some, Mr. Johnston, if you are still here, you are welcome to comment on the charter cap. And we're going to set this at 3 minutes for anyone who wants to speak for the public today. And if that can be extended, of course, if there are questions for the presenter. Mr. Johnston, welcome back.
Stan Johnston, 860 Poinsett Avenue, professional engineer, City of Titusville. I'm surprised because normally what happened is that when you have an agenda item, you go over the agenda item and then you have those who are in favor and those who are opposed and so forth. So I'm going to stop right here and sit down because I'm surprised that it appears to me this is not the general order of doing business. Thank you.
Thank you. Okay, next we have Sandra Sullivan talking about agenda item number 1. Welcome back, Ms. Sullivan.
Good afternoon. Sandra Sullivan, South Patrick Shores. I am not in favor of taking away the charter cap. We're going into perhaps a highly inflationary time period. We're getting increases on a lot of different of the aspects of the county. We just had a compounded 22% increase on our garbage disposal this week. So related to this, when I look at the finances of the county, there is a lot that they could do to address expenses. For example, we haven't had an impact fee revision or study for 15 or even more than 15 years, depending on the item. So until the county is more responsive in their planning, I am not in favor of giving them a way out with all of the other increases we are seeing. And a perfect example of that on that garbage disposal this week was they knew about this as an issue for 3 years. They waited until May to start building the facility. It won't be done until 2026. And so in October, they approved having to transport trash. And then 9 months after that, they asked, how are we going to pay for this? And let's do a study to figure out how we pay for it. Well, how they're going to pay for it is we're paying for the transporting of that trash to facilities for a number of years until 2026 with a 22% compounded rate increase on our fees. So if we take away the charter cap, we're not encouraging the county to do due diligence and finding ways to be fiscally responsible. And we're conservatives. We want fiscal conservative government. And this was put into place, you know, the voters wanted this protection. And I do realize there are not a lot of counties with this as being one argument for doing away with it. But we see this intense pressure. We know with growth comes a lot more expenses. The cost associated with growth should be accounted for by impact fees. And we do not have impact fees being evaluated for now for over being adjusted with a study for 15 years. And in 2016, they had a study on the transportation aspect, and they rejected it. They were told it's going to cost more. So those costs kick the can down the road, and guess who ends up paying for it? The people. Instead of it being the growth being fairly distributed between the developers and the people. Thank you.
Thank you so much.
Mr. Chair, can I make something clear?
Sure.
Unless I'm totally wrong, this is not about removing the charter cap. Right. Correct?
That's correct.
Okay, thank you. Just so the public's not confused.
Mr. Chair, can I comment on that?
Of course.
Yeah, this is definitely not a proposal to eliminate the charter cap. It's quite the opposite. It's the exact opposite. It's to add language to the charter to make the charter cap enforced, which it has not been for many years now. When the county commission votes to exceed the charter cap, they've made that increase above the charter cap amount, 3%, or the CPI, whichever is lower. They've made that part of the baseline budget. So the charter cap, although it exists in theory, it doesn't exist in reality because of the way the county commission has done its budget. So this uses language taken from a lawsuit started by Scott Ellis, clerk of court, assumed by Rachel Sadoff, clerk of court, takes the language from the county attorney, which said this is the language that would be needed to enforce the charter cap. So it's right from the lawsuit. I want to make it real clear that this proposal is to enforce the charter cap, which has not been enforced up to this point. Thank you.
Ms. Jenkins.
Can I ask a question? Mr. Leisenveld, can you tell us how many times the county commission has declared the emergency on the budget?
Twice for critical needs.
Twice in how many years?
Since it's been implemented, I don't know the year.
20 years? Probably.
Other questions, comments? on it?
Wasn't the most recent time that this was?
Mr. White, go ahead.
Yeah, I was just going to say, wasn't the most recent time when Sheriff Ivey came and asked for an increase in his budget that exceeded the cap?
Yes.
And that was only a couple of years ago, as I recall. And I don't think that they've gone back to enforcing the cap as it was prior to the Ivey increase, for lack of a better terminology.
Sir, I don't know all the details. It was 2 or 3 years ago, the last time they voted for a
Right.
critical need.
Mr. Tredice.
It was actually only 2008 that the charter cap was voted into office. It hadn't been 20 years. So it's been three times, I think it's been violated in what, 13, 14 years. So it's violated pretty frequently. And really, what does it matter if it's once? Once is too many. The charter says there's a charter cap. So I don't see how 1 or 3 is okay. Thank you.
I The only thing I differ on is that it was done twice, and that Ms. Trita said it was violated. It was allowed in the charter if 4 members of the commission voted to go past that. That's not a violation of the charter. If you want to change your word, that's fine.
Mr. Chair,
Mr. Tredice.
I'm not arguing that there wasn't a supermajority to exceed the cap. What happens next is that exceedance of the cap becomes the baseline budget for the next year. That's where the violation comes in. I'm not arguing that there's never been a supermajority. The violation comes in that the charter cap, it can only be for 1 year based on the wording of the charter, but the way the county budget has been budgeting is it's made a baseline, so it becomes a part of the permanent budget, which exceeds the charter cap.
I know what you're saying, however, the courts also ruled a different way.
Yeah, Mr. Chairman,
Mr. Fisher.
I just want to remind everybody also out there that we're the only county that has a charter cap. And I think that's totally unfair for Brevard.
Mr. Chair.
I have a quick question for Mr. Googleman. Are we pretty clear on what is a critical need? Is that definition or that threshold pretty fleshed out?
Mr. Googleman.
Off the top of my head, I don't know the answer to that. I suspect that it's probably what the commission makes of it, the county commission.
Mr. Langenfeld, that's pretty much in line? What the commission decides is, there's no governmental definition, correct?
I don't really have the answer for that, sir.
Okay, let's add that to the list of fun things to do for the next meeting. Mr. Tredice.
I'd like to point out that the lawsuit was not won or lost. It was dismissed on procedural grounds. That was appealed. The dismissal was reversed, which means the lawsuit is back in circuit court. So there hasn't been any answer at all by the courts on this.
Thanks for that information. Other issues? Okay. Let me just add one more thing here, just for procedure, because we're getting into public hearings and so forth. Again, this is hearing number 1. And as we're all looking at our calendars right now, it would be eligible, this item would be eligible to be voted upon on the 23rd of June, okay? So here's the options we have, just to lay it out there. We can have the vote that day after all the public hearings are done, or we can wait until the 7th of July to have the vote on one or more of these items. Again, and so just keep that in mind, and let me train of thought go further. I take good point to Mr. Moore's argument or point about we don't want to have a vote-a-rama, and theoretically we could have a vote-a-rama that day on all 8 of these 9 proposals, right? Because this is day 1 for all of them. I would prefer that we break it up at a minimum, because my guess is of these 9, maybe 4 or 5 will actually make it to the end. Do we want to have that vote-a-rama, or do you want to kind of line it up now so the public is aware that we're going to break it up so that it's done in a smarter way? That's one thing I want to think about. The second thing I want to ask, going back, it's kind of tripped my mind, is we've talked a lot about this 3-attorney panel. I think there are legitimate concerns about that for a variety of reasons. If we voted on an item on, let's say, June 23, when does it go to that 3-attorney panel? And the reason I ask that is that, let's say we lose there. If we're still scheduled to have meetings, does that mean we still have standing? And we can get away from asking you to do pro bono work? I'm being serious. I want to know that we're still in kind of session, so to speak, and if these 3 attorneys say they don't like what we've done, we can still get a bite at the apple so that the work that you're trying to get done here can be done. Are we still in session, like to use a legislative term, or once we voted on it, we're out of the mix?
Well, I think once you have finished with a particular item and send it on to the 3-member panel, I think then you're done with it. So let's say that at a meeting in June, you decided to go ahead and approve something. I suppose you could always take a second look at that at a July meeting, assuming you haven't sent the proposal on to the panel.
Okay, and again, I'm just thinking out loud. I want our work to be done. I don't want to see 3 people annihilate it. And if we do make a mistake or they point out something maybe we didn't see, I'd like the ability to make that amendment. And this goes to an overall argument. I think Mr. Tredis had a proposal before us that might change a little bit. I don't consider a change to be meaning you have to go back to start. I consider, like you would in the legislative process, that in the first committee it starts as one thing and it gets amended. Doesn't mean you have to go back to the beginning. So again, let me go through this thought process. If there's something that that 3-attorney panel doesn't like, is it your belief that we can go back and amend that? Or do I need to create a new vehicle that I could amend later?
I don't think anybody has ever considered that for 2 reasons. Number one, they just haven't, it hasn't occurred. But number 2 is if you look at the charter, as I was pointing out earlier, if the 3-member panel says, oh, this is inconsistent with the state constitution, the charter does not say what happens to it. That's something that has been omitted from that provision. It only talks about if it's approved by the panel, then it goes onto the ballot. But if it's denied, it's unclear under the charter.
So there's some lawyers in here, and I'm not one. I would just like to play one. But is there anyone who can kind of give? I'm going to ask Mr. Jenkins in a second. Is there anyone who? Does everyone understand my train of thought here? Okay, I just want to make sure.
Yeah, absolutely.
Okay. But please, Mr. Jenkins, and I'll go to Mr. Moore after that.
I was going to ask a question of Mr. Gugelman. My recollection is the charter says that the county commission will provide this body with sufficient funding to do their duties. Is that
Yes.
correct? Sufficient funding could include your opportunity to hire an attorney to represent you. And as I mentioned once before, one of the attorneys that we interviewed mentioned that he was representing an Orange County Charter Review Commission who challenged the county commission, and I think he said they won. So I think there are some avenues, but I also wanted to remind you that 3-panel attorney is looking at 2 things: constitutionality, and it's a single subject, not a multiple subject.
Constitutionality, consistency with general law, and single subject.
And with that in mind, at least the ones that we're talking about, in your opinion, of any one of these 8 or now 9 before us violate any of those, in your opinion?
Perhaps.
Okay, then I think that's something we want to take under consideration, as to say, because again, we're not here for our health. We want to make sure our time is worthwhile. Mr. Moore?
Mr. Chairman, I agree, and although I've said to Mr. Tredis that I disagree with doing away with the panel, I don't believe the panel is the ultimate stopgap. I think, if I recollect, Mr. Gugelman, they actually respond with a memo relative to their opinion, and if it had a concern on the 3 issues that they were looking at, and we were still impaneled, I would hope it would provide for us the opportunity to cure what may be there, presumably if it is past this body with a 10-vote requirement, that we would have the opportunity to cure. I think that's where Mr. Herodopoulos is going, asking how, by what mechanism would we use to do that after, hearing from those people.
Yeah, and my point is the charter leaves that wide open. It doesn't tell. If the panel finds something, say, inconsistent with general law, what happens? And the charter is silent on that. It only talks about if the panel finds that the proposal meets the requirements. So, and I think that's something that was just, for whatever reason, left out. And so the question is then, what happens?
And I think to that point, I don't want to get in a lawsuit, Mr. Jenkins. It's nice to know we have some money to do that. I think what we have done in the past, again, I'm just going through my past history, when the courts have ruled against us and we're still in session, we'll go out and read the ruling, and if we happen to agree with it and say, you probably make a good point where it is unconstitutional, we'll make that adjustment. Of course, there's a lot of definitions of what's constitutional or not, depending on which judge you pick. But that said, that's why I like the idea. We know we'll be here to the 4th of August potentially. And if we have a vote on the 23rd of June, I think we'll get a few more bites of the apple short of a lawsuit. And if we need a lawsuit, we still have some time to do that. So as long as we're in session, to your point, we have resources to hire a lawyer. And as long as we're in session, I think we have the right, and again, correct me where I'm wrong, to, if we get a memo back saying this is wrong, or we think it's inconsistent, and we happen to agree with them, we can come in, have another, adjust the ballot language, whatever it is, have a vote. If 10 commissioners say yay, okay, they'll look at it again, trust me. And at least we'll have a second bite. I'd like to do it that way because it's our time is valuable. Mr. Nye?
So now you've got the wheels turning for me. I'm wondering, should we add a couple of meetings, another meeting in June, and perhaps another one in May, since we essentially reset the clock today? Is that something that...
Well, I think it's a good point. The only thing I would bring up is the first vote could take place on the 23rd of June, right? That's what I'm looking at. We would have 3 meetings after that with potentially no work to do. Because I think that some of these proposals are done. I think there's only, in my opinion, I can say which ones, but I think maybe 3 or 4 might make it, or at least have potential for it. I think some are just going to kind of vanquish itself. But I'd like to have as many votes on credible issues by the 23rd of June, and that will give us those 3 additional dates. Do we still have, what's our last date we can actually do it? Is this literally the last day on August 4th?
The supervisor needs the ballot language. I believe it's August 22nd.
Okay.
And the last board meeting before that meeting is August 16th.
Okay, so I would ask this, is that, to Mr. Nye's point, if we think we need more meetings, we have the right to add meetings down the line, depending on what happens on the 23rd of June?
Yes. Oh,
Okay.
yeah, yes, sir.
And maybe by our rules, we can say only proposals that were handed in by May 12th, so that we don't just get a whole new rash of,
Yep.
Is that okay with everyone?
That was my concern. If you were,
Okay,
you
yeah.
were mentioning staggering them, right? Like potentially saying, okay, we're going to vote on these on June 23rd. And
Yeah, yeah.
then, so that's why I was thinking we
Right.
might need 1 or 2 more.
No, good point, good point. So everyone's comfortable with the, I'm sorry,
Yeah,
Mr.
I'm sorry, Mr. Chair.
Sure.
I just want to remind the commission, if you're adding more meetings for the discussed agendas, that the charter says 10 days apart for those 3 meetings.
No question, yeah, I mean, but I'm looking at the 23rd of June, right? And let's say July 7th, or on or before July 7th, we've heard back in a negative of one of our proposals. We could say theoretically put a meeting on the 19th and 20th of July if we wanted. And we could be that flexible. Because it's 10 days' notice. Yeah.
Well, it's, the charter talks, the 3 meetings of intervals of not less than 10 days.
Okay, so we can have one. All right, well, let's fight that animal when it gets there, but everyone sees where we're trying to go with this. I just want to be clear. Okay.
Mr. Chairman, I think looking at when the final date is for proposals, you'd have to go to that first meeting in July for 3 hearings.
Well, I'm looking at it, today is number 1, and May 12th is meeting number 2, and to your point, yes, so we would have anything new that comes down the pike, yeah.
Yes, and if it came to this board for the May 12th deadline, then you would have to go to July 7th for your 3rd.
I agree, but we also have warned, if you bring them in late, good luck, right? But that, to your point, that we still would have one meeting at the end that's still kind of open to suggestions, okay? All right, so again, just keep it in mind, I think that we can adjust times, we just need to be very conscious of the 10-day rule and so forth. So with that in mind, I just wanted to put that out there. And so the question that comes up after that long deliberation is, would you all like to vote on the first 4 measures on the 23rd of June after public hearings, or would you like to have your first vote on July 7th with some time to think about it?
Mr. Chair, June 23rd, I prefer. July 7th, a big vacation week. It's right after July 4th.
I really like to vote on the 23rd because by then we're really at meeting number 5 or 6.
Yeah.
So I would prefer a vote on our first 4 items on June 23rd. And maybe even potentially more depending on where we're at with some of the other proposals. Again, and I'm belaboring the points here, are we allowed to, even though we're not having a final vote on this, Mr. Leisfeld, if there are some proposals after we start discussing it that we think are dead, who would, in our old world, a senator or representative to say, I'm basically pulling my bill? All right. Do we have the right to, in essence, have a vote before 3 public meetings and say, hey, anybody want to get rid of this idea because I don't think it has legs, and vote it down so it's not even in the wish, or we have to let it have a slow death of 3 public meetings?
Remember my point, the charter says it only has to have 3 public hearings if you're recommending it to go on the ballot. If it's not going on the ballot, you don't require 3 public hearings.
Okay. I like that idea. Mr. Fisher.
The only thing that you might want to consider is a tentative meeting on May 22nd. I think if you did that, if you had a bunch of proposals in May, we come before the 12th, you do one on the 22nd, then you will have that other hearing in there that you can still do what you want to do by, 22nd of July.
Yeah, I would agree. Add one in May or add another one in June. That way we have another one built in if we're concerned.
And it depends on what you get between now and the 12th, though.
Yeah.
You might be
I
okay,
agree.
you know what I'm saying?
Yeah, good point. So they,
So May 22nd could be a tentative meeting date.
Sorry, Mr. Chair.
Okay.
22nd is a Sunday.
Oh,
I'm
well,
happy to come in,
23rd.
but
All right.
23rd, okay.
Maybe the 23rd.
yeah,
Sorry.
I'm still in town then. So
Okay.
why don't we figure out what happens, and if we need to, on the 12th, we can call for another meeting.
Okay, yeah.
That's a great point.
And I have a question, Mr. Chair.
Sure.
This is also a question for Mr. Gugelman or Mr. Leisenfeld. Is there a time frame that this 3-panel committee has to get back to us? In other words, could they drag their feet, or do they have only 7 to 10 days, which gives us a better idea of what we need to schedule and how we can proactively make this, efficient?
No, I don't believe there is a prescribed review time.
Okay.
That's a great question. I like that. Can we make a proactive request to the county commission that any proposal that is passed, literally ask them like tomorrow to say that they will agree to do an X number of day review?
Sure.
Right. Can we put that on the county commission agenda item?
If you,
Is that our deal? Can we say we must have the proposal or memo back within X number of days?
I think we can.
Okay, I agree.
I would have to double check the RFP language, but I believe so, yes.
Okay, good. I'd like to do that.
Well, if you adopt them on the 23rd, if you adopt some on the 23rd, you can automatically shoot those and start the process.
Right. And we just want to make sure we get a response within X number of days, too. So let's find out that answer. And obviously, there's a bunch of county commission meetings before the 23rd of June. Okay. All right, now we're done with all that. I'm sorry, Ms. Schmidt.
One other thing.
Sure.
The county commission is not in session for the month of June,
Oh, okay.
just so you're aware.
He just gave them the date, Sue.
Pardon?
He gave them the date.
She is correct. The county commission meets on May 17th. There's a zoning meeting, I have to look it up, 26th, 27th, and then the next board meeting is that first Tuesday after the 4th of July, whatever date that is. Yeah.
I thought you said June's up.
June 23rd, it would be your meeting, sir. July 12th, or excuse me, July 19th I have.
And one last question on procedural,
As well, too.
Leisfeld. It's, they have to have the proposal in by the 12th of May or the 2nd of May?
That is by the 12th of May. With that extra note there is if anybody wants it on the meeting that actually takes place on the 12th of May, we need it by the 2nd. You have a deadline and a meeting kind of meeting together.
Again, I'm boring you on the thing, but why don't we make the final day of submission the 2nd of May, so we don't have that ambiguity. Does anyone object to that? That we make the final day to submit the 2nd of May?
I think it has to follow the
No.
charter, doesn't it?
Mr. Gugelman knows better, but I believe that the charter doesn't have any restrictions or requirements on when proposals have to be submitted.
No, there is no requirement in the charter.
So we just say the last day you could turn it in is May 2nd, and then we don't have that ambiguity time of the 3rd through the 12th, right? Does everyone
Yes.
understand what we're talking about? Okay, so let's make the final submission date, instead of the 12th of May, let's make it the 2nd of May, so that if they're not on that agenda on the 12th of May, better luck in 6 years, right? Okay, so let's do that. Is everyone in agreement with that?
Yes.
All right. Without objection, that is done. Okay, so now we're back on proposal number 2. I think we completed the debate on proposal number 1 for the day. The recall of school board members, public hearing number 2. We have a bunch of appearance cards, but that recall issue is by Mr. Tredis. Mr. Tredis, you want to introduce that real briefly, and then we'll take up the public comment.
Yes, there's also been submitted a revised proposal from the original proposal. In the revision, what it does is it just provides for recall of school board members, whether there is a residential member district vote for school board or whether it's district-wide, meaning county-wide, because either could happen. So that's the revision to it. But the proposal tracks the statute, which provides for recall election of county commissioners and city council, the Florida statute. It tracks that very closely. It has the same number of petition required, the same percentages as the state law, the same time limits, the same time frames. Really, it tracks the state statute very, very closely. The only major difference between the proposal and the state law is that the state law provides, I think, for like 6 different grounds for recall, and my grounds are only 2, malfeasance, and then the second one is not more than 3 votes by the school board member with their vote recorded yes or no with a transcript, or as close as you can get to a transcript of the motion that was made. So what it does provide, it really provides for the recall of school board members based on their policy decisions, based on what they decide. And I think that the reason that it's become necessary of years of late is because of the school board's decisions on mandatory face mask wearing in schools, and its transgender policy, which is on a 1-page form on the Brevard County website, which provides that teachers and all school personnel must call kids K through 12 grades by the name that they say they want to be called by the pronouns that they want to be called by. It also requires that teachers and other personnel not inform parents that their child comes to school and assumes a different identity. If a boy wears a girl's clothes and wants to go by Susan, then the school teacher cannot tell the parents. It has to remain confidential, which violates the Parental Rights in Education bill just signed by the Florida legislature, which is a big reason why there might be a recall. It requires that the schools allow boys to use girls' bathrooms, locker rooms, and showers. Same thing for girls use boys, boys use girls. They have to allow that. And it also has information on its guidance, which has website information that would help kids transition from, quote, transition, end quote, to the other sex. So that's another reason why I think this recall election proposal is needed, and those are the 2 main reasons, and that's it. Thank you.
Thank you. Okay, we
Mr.
have,
Chairman.
Ms. Schmidt, for a question, or?
Well, just for Blaze, just so the public knows that you withdrew your first proposal, you put that in your memo, and then you came out with the new revised. I think that way people won't be confused on what is being presented.
Right. That fairly sums it up.
Okay, and this, the proposal, regardless, this is hearing number 1. We know what the proposal is. And as we've mentioned before, we're looking at this process where if you make an amendment, doesn't mean you have to go back to the start. You're just, it gets amended as we hear more comments from the public, let alone from the fellow commissioners. All right, thank you, Ms. Schmidt. Great question. We have Gene Trent here to testify. Mr. Trent, welcome. And everybody is going to give him the opportunity of 3 minutes to present, and then, of course, whatever time necessary to answer questions from the commissioners. Mr. Trent, welcome.
Well, thank you. Gene Trent, resident of Cocoa Beach. I'm here to speak. I'll be brief. I'm a candidate for School Board District 2, and as a potential future school board member, I'm in favor of any type of recall of an elected official. I believe if I was in the hands of voters to put me in that office, if I lose their confidence, I should be able to go back into their hands and be recalled. So I would be for that. I just want to let you know.
Thank you, Mr. Trent.
Sure.
All right, next we have Sarah Mirsky. Thank you so much for joining us today.
Thank you. Get my notes here. Good afternoon, Chairman Herodopoulos and the County Commission Charter Review. My name is Sarah Mirsky. I'm a wife, mother to 2 children in BPS, registered voter, taxpayer, constituent in District 2 for school board and in District 4 for County Commission. Thank you for your time and for volunteering to be on this on this County Review Board. Today I'm speaking in favor of adding school board members to be able to be recalled. I do think that all elected officials in Brevard County should be able to be recalled. But I know today we are addressing the ability to add school board members to the county charter to be able to be recalled. This is a bipartisan issue. Let me repeat, this is a bipartisan issue. I'm originally from Chicago, and unfortunately, I'm no stranger to elected officials on both sides of the aisle going to prison for crimes they committed mainly against the taxpayers and voters. Speaker of the House, Republican Dennis Hastert went to jail for crimes. Democrat Governor Rod Blagojevich went to jail for selling President Obama's Senate seat, amongst many aldermen going to jail for defrauding the voters and taxpayers. When I moved from Chicago to Seminole County, our county tax assessor, Republican Joel Greenberg, went to jail and was recently sentenced for defrauding the taxpayers. The voters of Brevard deserve to have the right to recall school board members, especially when they are clearly violating the law. Thank you.
Thanks, Ms. Bresky. Stan Johnston. Welcome back, Mr. Johnson.
You don't hear me yet. Stan Johnson, I'm for this also, but I think I'm pleased to be here before such honorable people in our community. I know serving county commissioner and county manager and so forth, and I even used to work for Mr. Jenkins and so forth. So, but what I'm here is that I did something a few years ago, and that's why I have a little bit of experience in it. Is that I had some trouble with city of Titusville, and it came to the point where I even sued him. I sued him for breaking the Sunshine Law, and well, what they lost. They lost and paid my attorney fees and court costs and so forth. So you're in the same situation, and I don't see that you're making progress on this this problem that you've announced. Although you say, hey, this is hearing one and so forth like that, but all these decisions that you've made in these other meetings, I don't know what's going to happen. Like, for example, when you have these minutes, all these minutes, as far as I can see, they're all illegal. They're all illegal, and they should be dealt with. And Mr. Googleman, or whatever that name is that it just seems like you're missing the point. And you should be addressing this issue as if it's genuine. You've broken the law, and you need to make amends. In other words, as far as these other meetings, and I just see that you brushed me off. Thank you.
Mr. Jenkins.
Stan, let me clarify for you. This is my understanding. The earlier meetings were advertised. They were announced. They were just not advertised as a public hearing. So the meetings were legal. The public hearings are starting today.
Okay.
Yeah.
Thank you for that clarification. I appreciate that very much.
So you agree with us now? We're okay then?
Well, I don't know. Mr.
I gave you the
Jenkins is
win
a
on the
smart
first
man.
one.
He's
Yeah, give us the win on the second
I'm
one.
going to say is that I'm not an expert at this. I'm really not an expert. I mean, I had my attorney to handle this thing, and you guys are smart, and I want to say is there's a lot I don't know. So thank you very much.
We appreciate bringing
God
that point.
bless you. Okay.
Mr. Chair, I
It's last one.
apologize. Mr. Jenkins is correct. Every meeting's been advertised. The last two meetings you held, April 7th and March 24th, March 24th and February 17th, you wish to also be advertised as public hearing. We didn't do that. But every meeting has been advertised, every meeting has been notified properly.
Thank you. Thank you, Mr. Jenkins, for that clarification. Carol. And if you could pronounce your last name perfectly, that'd be great.
Hello, my name's Carol Vyhansky. I am one of the original folks who spoke with you back in January and brought this issue to your attention. I just want to thank you all for spending so much time and effort researching this and listening to all of us, and now it seems like you're going to have an extra meeting to hear from all of us again.
Two more.
Two more, yeah. I'm just going to go back to what I said back in January, and that is the bottom line. Why should school board members have complete immunity from recall in our county? Section 5.2 of the charter allows for the recall of certain elected county officers. Now I'm hearing that it only applies to county commissioners possibly, even though it says that the officers listed in section 4.2 are also subject to recall. It seemed pretty clear to me when I read it that that would include the sheriff, the property appraiser, the clerk of courts, the supervisor of elections, and the tax collector, because they are all listed in section 4.2. But now I'm kind of confused as to whether that's true or not. But the bottom line is, right now, there's no path forward in our charter to even be able to attempt a recall of a school board member that may be committing malfeasance or some other act of misconduct, and this is what we would like to see changed. Thank you very much.
Thanks, Ms. Lyhansky. Great to see you. Thank you. All right. Carrie. Welcome back. Thanks for taking the time to visit with us.
My name's Carrie Tkach. Good afternoon. I'm here to speak in favor of adding the recall to of the school board members to the county charter. It's incredible that people with so much power over our schools cannot be held responsible when they stop representing their constituents that voted for them. Over the past year, we've lost thousands of students at Brevard Public Schools to homeschooling and charter schools, a trend that continues to soar. While our school board mediated renaming a school for an astronaut without even asking him first, we have Title I schools like Endeavor, where ceilings leak rainwater into buckets around students while they try to receive an education. This past week, Ralph Williams Elementary had no air conditioning. Students were experiencing heat exhaustion as their parents were called to come retrieve them, again, not receiving the excellence our school board has claimed to provide them. These are issues that should be of the utmost importance. Parents and bus drivers attend meetings and are largely ignored by the school board. They're met with eye rolls and contempt. Sometimes attendees cannot even get into the building to have their public comment heard. The voice of the people goes unheard with little respect, as the board continuously tries to cut public comment time. Brevard County families have no recourse other than to take their children elsewhere for an education without an avenue to remove inadequate board members. Thank you for your time.
Thank you very much. All right, next we have Katie Delaney. Welcome back.
Thank you. So I've been in every meeting
you guys know where I stand, and I hope that you hear us when we speak to you. This isn't about one person. It's about us as parents being able to hold our school board members accountable for the education of our children and for the safety and well-being of them. And like other people have mentioned, you know, our buildings are falling apart. Our education system, it's a mess. And our kids are failing. They don't know how to read. They don't know how to do math. And we've lost this year 10,000 students. That's $90 million. And now the school board wants to raise our property taxes because they say they have no money to give our teachers raises. Well, maybe if they didn't break public trust, they wouldn't be missing $90 million. So I please ask you, this is not about one person. It's about the future generations. We need to be able to hold our school board members accountable. Thank you.
Thank you so much. Liz Mkhitaryan. Take your time. Welcome back.
Thank you. I am Liz Mkhitaryan. I'm also from Titusville. There's a lot of different people from Titusville. I will just say that. Good afternoon. I appreciate the opportunity to speak with you once again about an incredibly important issue to me and to others in the county, and that is the issue of truth. At the last meeting, I made public comment to actually assist you in avoiding public perception. I was then challenged by one of your members that I was not providing evidence. So I felt the need to come back today to provide a little bit of evidence. I could expose the very deep connections of some of you members on this panel to Moms for Liberty and all of the speakers that you just heard from, who are all members. And I will proceed, who are prompting this push for change. But I won't, because I was treated with respect. I was allowed the chance. I think you even gave me some additional time, and I appreciated that. What I didn't appreciate was being, I guess, put on the spot when my intention was to come and just let you know that people were talking. So I would like to provide Ms. Rogerson and the rest of you some facts. Representative Randy Fine leads a very public dialogue about jailing one school board member. Representative Fine is deeply involved in Moms for Liberty. He threatens that harm will be done to our school district. Fact, 2 members of Moms for Liberty came before you to initiate this action. The official sponsor of this action, Mr. Tredis, has made very concerning remarks about his opinion about issues, and that is how he is planning on moving forward. Opinions, you know what they say about those. So after standing at this mic as a citizen with that gentle tip, I wanted to just provide some of the reason why the perception is actually the reality. Ms. Rogerson is a high-ranking official of Moms for Liberty, the very group pushing you to make this recall happen. Ms. Rogerson ran the unsuccessful school board campaign of the defeated school board member who founded Moms for Liberty shortly after that defeat. That defeat was by the current school board member who this recall seems aimed at. I disagree with the speakers that say, no, this isn't about a person. And again, I think I stated publicly the last time, I would be fully in support of instituting this, but not in this untruthful manner. So these revelations move us from perception to an alarming truth, that there are connections here that are of great concern for your constituents. You will rule on this, but please know that your actions are now officially seen as being prompted by a clear retaliation effort against the school board members. Retaliatory leadership is not democracy. Don't be complicit in these very transparent actions. And a final tip, don't ever try to discredit an educator, especially those of us who are retired, because we do our homework. Thank you.
Thanks, Mr. Karen. All right.
Mr. Chair, am I allowed to make a
Oh, Ms.
clarifying
Rogerson,
statement?
yes, for a comment.
Just so that everyone is aware, I am the Executive Director of Program Development at Moms for Liberty, unashamed. To clarify for several of the members that have spoken today, I do not know the membership status of the people who put forward this proposal for recall when they made the proposal for recall, but I believe they would appreciate it being noted that they are not current members of Moms for Liberty. So for their sake, I would like to clarify that. I would also like to clarify I did not run Tina Duskovich's last unsuccessful campaign as I was running for office myself at that time. So,
Okay, thank you for clarifying that. Thank you very much, Rogerson. Okay, Nick, is he? He had to leave, okay. Okay, that concludes the public comments for agenda item number 2 by Mr. Tredis. Okay, we have some more. We have Mr. Robert Burns. We're still on number 2, yeah.
Thank you, Mr. Chair. Robert Burns Vieira, and I've spoke on this before, but since this is our first hearing, I guess I wanted to reiterate the points I made before. One thing that I think is very important in our government is consistency. And inconsistency is the reason why we're having this issue now, because we have some inconsistency in our Constitution on which elected officials can and cannot be recalled. Every speaker so far that's gotten up here in favor of this proposal has said the same thing, that they think that elected officials should be able to be held accountable by the voters. And I agree with that 100%. I think that every elected official should be able to be recalled. But I think what we're doing with this proposal is creating the same problem that we're trying to address, and that we are focusing not on one person, but on one office. So if that person that you have a disagreement with or that you think should be recalled runs for another office, say tax collector, now we have to wait another 10 years before we have another charter review to put forth a proposal to say, well, I think charter review or tax people should be, whatever I just said, tax people should be able to be recalled. You know, so I think the proposal should be anyone who is subject to being in an elected position that should be able to be recalled. The county should have the authority to recall that individual for any office, because every person came up here has stated the same thing, that they think that voters should be able to hold them accountable. That should not apply to just one office. That should apply to all elected offices. That's all.
Thank you very much. Any questions? I see there are 3 additional cards from people who have already testified. We've already heard testimony. I think Ms. Rogerson responded, I think, with articulation, where I think we're ready to move forward. We're still on proposal number 2. There's been a lot of discussion about, should everyone be subject to recall? That's something, obviously, we have 2 more public hearings. Think about that as a group. If you think there are other positions that you'd like to see included in that, of course, we can have that debate. Let's also clarify that what by Florida law cannot be recalled. Let's make sure that we don't even get into that, so we get thrown out right at the beginning. So I think that's in mind. So without any other issue, we'll go into issue number 3, which is full-time commissioner, public hearing number 1, and that is by Ms. Sandra Sullivan. I believe you're still here, Ms. Sullivan. Yeah, please come on up.
Sandra Sullivan. So I just want to state, just for clarity, it's not that the commissioner is full-time, it's just that the commissioner not have another full-time commitment. So there's a difference. It's not saying the commissioner has to be full-time, it's that the commissioner doesn't have another full-time commitment. So I just wanted to reiterate, we discussed this before, but the heading is just a little bit, might be a little bit not clear.
Okay.
Thank you.
Thank you.
Mr. Chair? If I may, just based on past experience, having worked in a commission office for 5 years and having a boss that works full-time as a nurse practitioner amongst other things, and the hours that I know she put in and our office puts in, that I don't know of any commissioner that doesn't go above and beyond. And working extra or having a full-time job, I don't think that has any bearing whatsoever on their abilities. I'll defer to our past distinguished commissioners if they want to weigh in and share that about the hard work they've done and their staffs do. But for me, this is one of those low-hanging fruit ones where if there's no objection, I'd like to make the motion to drop it right now.
Second. All right, any other discussion on that? It has been seconded for a motion. Any other debate before we vote on that motion?
I would just add that it's pretty hard to define what's full-time. You could be an entrepreneur and own 5 businesses, and is that full-time or not? So I don't know how you define full-time.
Okay. Any other comments? All right, so we're going to do the yeas and nays here. We don't need a roll call. All those in favor of the motion to dismiss this item from our consideration say yay.
Yay.
Yay. All those opposed say nay. Okay, we are going to then, by your vote, remove that item from our agenda item as far as full-time commissioner. Okay, we are now then on proposal number 4. That is also by Mrs. Sullivan. And Ms. Sullivan, if you wouldn't mind coming up again, please, and presenting that for us, that'd be great.
Yeah, so Sandra Sullivan, I guess we're hearing number 1. So the idea is that what is currently laid out, the way it works is it's not defined where you go to do that annual process, which is if you go ask a commissioner office and you might not get an answer, and you might have to go to another commissioner office to get an answer, and you eventually find out that there's a obscure website that you can go to that is once a year you can submit a proposal, but that is in December and people are real busy with their kids and Christmas and holidays and all of that, kids getting off school early. So one of the things I suggested is just some clarity on the item of revising the citizen process and maybe opening up that form to where it's available not just 1 month a year, but with the entire year, or even a place of where you could look for it. So it's just the process isn't there, and there isn't a process to get something on an agenda item. I used the example in the other meeting where I was trying to get a formerly used defense site for my community, and I wanted to get the item on the agenda. I couldn't get an item on an agenda. So I'm just asking for a little more clarity on a citizen-driven process to get an item on an agenda or to put a proposal to the county that is driven by the people.
Thank you so much. Are there questions?
Mr. Chair?
Yes.
Again, I'm going to go back to my past experience. Actually, you can put anything, go to any commission office and do a citizen's agenda request item. So that process is, not to say 24/7, 365, but whenever commission office is open, you can do a citizen's agenda request. So unless my distinguished other commissioners object, I'm going to make a motion that we drop this.
Wait, I just have a
Mr. Nye, sure.
So, but the commissioner could decline, right?
Absolutely.
Okay, so, all right, that answers my question.
Okay, other comments? Is this a motion? Do you like to?
Yes, I'd make a motion we drop this going forward.
Mr. White, for
Yeah,
debate.
I was kind of puzzled by this. It almost sounded like the proposer of the amendment was saying that there's this obscure process by which, even if you've been turned down by every single one of the commissioners, that there's still an opportunity for you to be able to get something on the agenda, just as a citizen, even though you've been turned down by all 5 of the commissioners. Is that what we're referring to?
We did it in 2010.
Some way to make that process more reasonable and more open, and
Ms.
more
Sullivan?
available?
I'd refer to Tom on that.
You can get on any county commission agenda every week. They have public comments. If you can't persuade 3 of the 5 commissioners that your subject is worthy of investigation, then it doesn't go anywhere. But you have ample opportunity to present. What the charter did a few years ago was to create a formal process. It's really more for show than it is for reality, because you can come in any week at a county commission meeting and make your presentation.
And Mr.
Make it-
Jenkins, clarify this if you will for me. Not only can you do a public records, do a public comments card, but you can actually fill out a card for every agenda item, right? So you can be heard multiple times throughout a meeting. So there's plenty of opportunity to be heard.
That is correct. You can speak to every item on there, even if it's on the consent agenda. It can be pulled if you have asked for it, filled out a card, and then you can also comment under one public comment. And I'm not going to pick on you, I don't mean it that way, but the last meeting, I believe you spoke to 4 different issues. 3 issues and 1 public comment, I believe.
Yes, so for the 3.5 years, I've been speaking regularly at commission meetings, but that doesn't mean there isn't items that you want to put on an agenda and request. So I'll give an example. There was at the budget meeting for the county commissioners, there was a group of people that wanted to put on the ballot the EELS program because it's going to sunset, and if it doesn't go on the referendum this year, it will sunset, and there won't be funding for maintenance of those lands. They put forward that, and essentially the commissioner said, because we're not in favor of funding any conservation lands, we're only in favor of maintaining it. And so it didn't move forward with anything. So with the way that this process works, the part that's obscure is the way that the charter is written right now. There's no place in there that tells you where you go to submit this proposal. But in the way it works right now, only once a year for the month of December, you can submit a proposal. But if a group of citizens want to submit a proposal, say, for example, to initiate some ballot language to put EELS on the ballot language at this referendum, they can't, there's no mechanism to do that. So this is about enabling the citizen process without having to go out and collect, 70,000 petition signatures to put something on the referendum. It's just a formal process to submit something to the county commission to be considered by the commission with public. But if commissioner doesn't want to put it on an agenda, you can't put it on an agenda. One person can go up and they can speak in public comment, but it's not putting it as an agenda item where there's action taken on it.
Mr. Nye.
Yes, so I was on that Charter Review Commission where this proposal came out of the original proposal, and the entire point was not to have the public be able to comment. It was be able to force the commissioners to vote up or down on a specific suggestion. And so, this notion that you can go and try to get on the agenda or make public comments, as Ms. Sullivan said, you can speak till you're blue in the face and not get anywhere. And so this was to give people an outlet where if they had a genuine suggestion, that even if it was, from the commissioner standpoint off the reservation, the commissioners would be forced to vote on it up or down. And I was absolutely 100% in support of that. And I think, given how this has played out over the last, whatever it's been, 12 years, I would be in favor of increasing the frequency, the window, to maybe twice a year or once a quarter. There's a happy medium there, but I do agree that it seems like it's not been utilized, or at least most people don't even know about it. Right. And once a year, that it's, if you miss it, like you say, now you're off for a whole nother year. So I would be open to increasing the frequency of the window. I don't know if you want, from just a logistic standpoint, once a month or something like that seems too much, but once a year seems like too long based on what's happened so far. So, thank you.
Thank you.
Any other further comments?
Quick question for Ms.
Sure.
Sullivan.
Ms. Sullivan, more
real
question.
quick. I think one of the issues that we have here is that, you talk about putting in some petition signatures or requiring those so that it's not just wide open either. We don't want floodgates for anybody to just come in and put things on and burden the commission with, things that are just not really pertinent. However, we do want it to be open, right, for those that have proposals and for the commission to review those. How many petition signatures would you want? Can you clarify some of that information for us?
I was going to defer to this commission with your experience to what would be reasonable just to have something voted on.
Okay. And is there any other measures that you suggest to kind of weed out some of the less formal requests?
I'll choose a number, 1,000, adjust it accordingly if you think that's too few, just for simply to put something on a commission meeting so that they can take a vote on it.
Okay.
It's just a step in the process, but,
Okay, thank you.
Mr. Trettis.
I think it's a good example of why there should be a precise language with underlying language that you want added to the charter, which is, I don't think you want any deletions here, you just want an addition. But, it's hard to take a vote or even discuss what you're talking about when it's in such general concepts and ideas and so, vague, really. So I suggest if you really want to try to get some traction on your proposal that you put it in exactly the language that you think it should appear in the charter, so we actually have something to discuss rather than these vague concepts.
So on that, the form didn't work that way, so that's why I didn't do that, but I can certainly take that feedback and come up with some language. I kind of thought you guys did that.
Sure, good question. Mr. Fisher.
So,
Yeah. In the 8 years that I served as commissioner, there's numerous of residents have come and given me an opinion on what we ought to do and shouldn't do. And if it was worthy, we discussed it and we brought it forth to the other commissioners. If it can't get through 5 different commissioners, and typically if the issues are very important, the person presenting will go to all 5 commissioners and present their case. And I think that our commission has been open. They might not agree with you, but they've been open to listen to your suggestion. And if you can't get past the 5 commissioners, I don't think we need to be superseding it and trying to get it on a ballot some other way.
Okay.
well, if that's the feeling of the entire commission, maybe you need to remove the citizen process from the charter altogether, if that's your position, sir.
I would be okay with that too. Yeah. Last time when they came forward and most of the issues that came before us, I remember the county was already doing them.
Okay, we have a motion on the table.
And if I
Mr.
can
Lubert,
clarify,
you wanna
if I can get a final comment in.
Yeah.
Mr. Trettis made a very good point. I think if this was specific in language and something comes forward before the deadline that is, then maybe we have something to talk about. But right now, I think my motion stands.
Second.
All right, we have a motion on the table. Any other debate on this before we vote? Mr. Trettis?
I just want to point out, I'll vote to table it or to vote it down just because it is in vague language. This is debate. There was a second.
It was a
Yeah,
second.
Mr. Fisher seconded.
We're in discussion. Okay.
There's still debate.
So,
You just can't make another motion, that's all I'm saying.
no, I did not make a motion. I'm just arguing. No, listen. So I'll vote it in favor of knocking it down at this point with, I guess, without prejudice is the terminology I'm used to in court, which means you can bring it back with specific language. That's all. Thank you.
Okay. All those in favor of taking this away, are in favor of Ms. Lupiker's motion to remove this from consideration, say yay.
Yay.
All those opposed, say nay.
Nay.
And by your vote, by your vote, the is approved. And so we're going to strike number 4, the citizen process from the.
Mr. Chairman, just for clarification, for Ms. Sullivan's sake, before we move on, nothing that we've just done would prevent her from coming back and submitting something in the format that Mr. Trettis was suggesting by the deadline to see if she can't get some additional.
Yeah, and that new deadline is May the 2nd. That's correct.
Okay.
Correct, and I totally
that
agree with that, Bob, and I appreciate the clarification.
Sure.
All right. You're not on the committee.
I know.
Okay, thank you.
The thing is, I have speaking cards, and you're not recognized.
Okay, Mr. Johnson, you're recognized on item number 3.
And number 4.
You want to speak on one or both?
I have speaking cards on both.
Okay, well, let's come on up. Speak on number 3 first, and then we'll go to number 4.
Okay. You are correct. I do not have the right to call a point of order. But the thing is that Mr. Haridopoulos is that you should be going according to the Robert's Rules of Order. And the thing is that when I had a speaking card on F3, You went ahead and had a vote without allowing me to speak. That's not with Robert's Rules of Order.
Well, I'll tell you what, here's what we're going to do. We're going to hear you on point 3, and we're going to hear you on point 4, and then we're going to vote again. Is that okay with you?
Yes, sir.
Okay, you got it.
Thanks.
So finish on 3.
Okay, 3.
Thanks.
Okay. On number 3, I pass.
Thank you.
Okay.
All right. Without objection, we'll have another vote on number 3. All those in favor of Mr. Lubiker's motion say yay.
Yay.
All those opposed say nay.
Nay.
By your vote, the number 3 is removed from consideration. Now we're on number 4. Mr. Johnson, you're recognized.
Okay. Thank you, Mr. Herodopoulos, for recognizing
You're
my
welcome.
speaker card. Thank you. And thank you for going again with another vote. Okay. On item number 4, I pass. Thank you.
All right. All right, we're going to have another vote on item number 4. All those in favor of the motion say yay.
Yay. Yay.
All those opposed say nay.
Nay. I got mine out of order. I was
Thank
supposed
you.
to be yay. I'm sorry.
Thank you. By your vote,
Sorry. That's why everybody looked at me.
item number 4 is removed. And as Ms. Sullivan, I think people see the credibility of your idea. If you can work with staff or what have you, I think that would be the best condition to go forward. Let me just make sure that Mr. Johnson's not in I missed this for number 6 or thing. Okay, you're not in that. Oh, you are number 6. Okay. All right, so we are now on the number 5, which is to repeal the 3-attorney panel. And that is, Mr. Tredis, are you on that as well?
I am.
Okay, you are recognized.
Thank you. This proposal would repeal from all where it's mentioned in the charter, the 3-attorney panel that reviews charter proposals. And we've already heard the history of it, but some of the reasons for it are, first of all, we're the only charter county in Florida that has this 3-attorney review panel. And I think it's rather undemocratic to have a group of 3 lawyers who are paid by the county commission have the ability to strike the work that we've done and prevent our proposals from going to the people for a vote. I've sort of argued this at the last meeting, I think, where we have the ability to hire additional lawyers if we wanted to hire additional lawyers for opinions on whether a proposal is consistent with Florida law, consistent with the Constitution. Additional lawyers in addition to Mr. Googleman, who has already opined on this proposal. No, excuse me, that was a recall. But like on the recall, we could have hire lawyers in addition to Mr. Googleman. But it's also a conflict of interest because, for example, my charter cap, I'm pretty sure that 4 out of 5 county commissioners are against my proposal. And for that same county commission who is against the proposal to be able to hire lawyers who would pass judgment on it and would have the ability to basically end it at that point, I think is a serious conflict of interest. And there also, it could be subject to abuse because the county commission could decide that the word shall means may. There's case law which says that. That was in Mr. Googleman's opinion. Also, simply the fallibility of attorneys' opinions. I mean, I think on the recall proposal, I think Mr. Googleman opined that he didn't think it was consistent with Florida law. However, when I asked if that were litigated into the circuit court or appellate court, could those judges find to the opposite, that it is consistent, and his answer was yes. So these attorneys' opinions are so fallible and so subjective anyway. That's another reason why it's unnecessary. And those are some of the reasons for the proposal. Thank you.
Thank you. Any questions for the presenter? Okay, we don't have any appearance cards. The only thing I would add on that, we've already had a discussion today about what happens if, right, the 3 attorneys don't go our way. Would you be open to the idea of amending it so there is some type of appeals process as opposed to, because one thing we don't want to see happen is we act, there's either a clear violation or in other words, you want some type of appeals process, or you just want complete elimination and maybe there's a vote and it passes and later people challenge that idea and then we lose in the courts. What's your pleasure?
My pleasure is not to amend. Again, we're the only county in Florida that has it. I think it's bad all the way around.
Okay.
And also the time frame. I mean, we're already talking about how will there even be time to do anything at the end of the commission's term? And it's too tight, I think, to now try to build in an appeals process. So for those reasons, no.
Okay.
And I don't know if this is out of turn or if you want to wait until the end for this, but Mr. Gugelman brought up earlier that there needs to be some clarity on the issue if the three-person panel stays. If this doesn't pass and we do have the three-attorney panel, then, how does it come back to us if it comes back to us at all? Do we have that option? So I wanted to see if anybody wants to volunteer so we don't have multiple different proposals coming in. And is that what you meant by that, Mr. Gugelman? Was that an insinuation that it needs to be in the form of a proposal?
It does if you plan to keep this provision.
Okay.
And I think Mr. Tredis is taking the position that, no, the provision needs to be ditched.
Okay.
And that's why I brought up the issue. I wanted to see if we as a group wanted to have an appeals process, a quick one, so to speak, or at least a clear line of order in which we can get around whatever concerns they might have. But again, it's Mr. Tredis' idea, however he wants to proceed, but again, we have 3 meetings in this. So again, we can think about this more. This is obviously an idea that has credibility. So I don't think we need to make a vote today. There's no public hearing, no public comment cards, at least on this point, as far as I know, in number 5. Correct? Okay. And at least it's in front of me. So this is still live for next time. If you want to come up with that suggestion, if we want to go through an appeals process, or that's the will of the commissioners, we can do that. We have 2 more hearings in which to hear these ideas. I just wanted to bring that up because we've already kind of created our own process, haven't we? In case we don't get our way. It wouldn't be bad if we formalized this since we do have concerns about it. But it's Mr. Tredis' idea, and I do not want to trample all over it. But I do want to see if we can come up with a way that we don't have this ambiguity in the future. So,
Okay.
Great point. Thanks.
Thank you, Mr. Chair.
Ms. Fisher.
One question, and Mr. Jenkins might remember this, but some reason I believe that things have passed through this committee and it's been challenged before in the courts. It didn't hit the 3 attorneys, and it's been challenged before, and it was ruled unconstitutional. Am I right on that, or?
Yes, one in particular comes to mind, but I suspect there's been more than one.
Perfect. All right, well, and obviously this idea is still under consideration, and we'll have 2 more hearings on it. If you all want to come up with a process, we can. If we don't, we just roll the dice as we talked about before. No problem. All right, number 6, we have the right to clean public water, public hearing number 1. And Michael Myjack, I think you're here. Are you? Oh, there you are, sir. And we have a bunch of appearance cards on that. Welcome back.
Thank you. Starting over, huh?
Yes, sir.
Okay.
Okay.
Esteemed members of the Brevard Charter Review Commission. I'm Michael Myjack, and I represent myself and my colleagues on the Indian River Lagoon Roundtable. We're a nonpartisan, non-affiliated grassroots organization that explores environmental issues having significant adverse effects on the Indian River Lagoon estuary. Today, we're here to propose the Right to Clean Water Charter Amendment out of a shared desire and need to save the Indian River Lagoon, the St. John's River, and several natural wonders which, in years past, have seen much demise. Our Florida State Constitution charges its citizens in chartered counties and municipalities with the power and responsibility to protect our citizens, our businesses, our visitors, and our economy from legalized harm. But what about our waters? Who's protecting our waters from legalized harm? Today, we have no fundamental right to clean water. We have a Clean Water Act, but not an indefeasible fundamental right. And we won't unless we declare it in our charter. Just like in the Bill of Rights, or amending our U.S. Constitution, amending our charter is amending our charter for the right to clean water. By many measures, we're in a better place today than we were in 2008. Our hotel industry is growing every year. The space industry is taking off again to reconnoiter space. And nevertheless, there is economic harm in our healthy, or lack of a healthy environment right here on planet Earth. And rest assured that restoring a dying estuary is no more daunting a task than conquering space. And yet whole industries are now depressed in Brevard County because of the state's failure to maintain healthy waterways, wetlands, and habitat. Remember our vibrant shellfish industry? That was last millennium. The last time I remember shellfish out here was in '96. And then we had a heat wave, and then no more shellfish, no more clams. We used to have redfish and tarpon. We had tournaments, annual tournaments. And the O'Galley fishery was world renowned. Where is that today? Economic harm. Clearly, we the people recognize that our lagoon is dying. In 2016, we started taxing ourselves a half-cent sales tax to help clean up the mess that the state has left us with. The Department of Environmental Protection and the St. Johns River Water Management District are the permitting agencies that are responsible for our waters, which are no longer clean. We lost our last Class 1 water just 2 weeks ago. Cypress Lake, Blue Cypress Lake, which had been spread with biosolids from Miami, has now got an algae bloom that drops it to Class 2. So there are no more clean water in Florida. I ask you, after taxing ourselves a half-cent sales tax and a price tag of over $500 million in the last 5 years, is there a more egregious form of economic harm that we have granted ourselves to try to fix because of a problem granted by our state? Declaring the right to clean water in Brevard County gives the county commission a foothold to take the DEP and the St. John's to task to clean up our waterways for the benefit of our economy, our visitors, our business, and our citizens. Thank you very much.
Thank you, sir. Are there questions? All right, thank you so much for presenting today. All right, we have a few folks with appearance cards. Bill DeBusk. Welcome, sir.
Good afternoon. Thank you all for being up here and serving. And as members of this board, well, my name is Bill DeBusk. I'm from West Melbourne. Sorry. As members of this board, you represent the citizens of this county, and your job, essentially, as I see it, is to recommend things that the Brevard County citizens will likely approve. So that's kind of where I think your basic job is. In November of 2020, Orange County, Florida approved the Right to Clean Water Charter Amendment by an 89% voter approval. Clearly approved. Brevard County in 2016, 62% of voters approved a half-cent sales tax to save the Indian River Lagoon. These examples show undisputed evidence that Florida citizens and the citizens of Brevard County want the right to clean water. Florida citizens from all political spectrums agree that clean water and healthy ecosystems are vital to their own personal welfare and the economy. The state government and the current regulatory system have failed. They have failed to protect the basic rights of people as well as the natural world. For proof of how ineffective this current system is, simply look at the Indian River Lagoon. You know all the stuff. It's got F-, MRC, it's got muck, it's got dead manatees. Hopefully, some or most of you are around long enough to have seen the Indian River before it was destroyed by pollution. If so, you definitely know that the current environmental system hasn't worked. Clearly, the citizens of this county know that the government and environmental protections and regulations have failed us. They have proof, and they will certainly vote for the right to clean water because they know it's vitally important. You all have the privilege to represent the citizens of Brevard County. and to elevate these amendments and make recommendations that these amendments that support to make recommendations of amendments that support the interest of the citizens. So you're fundamentally obligated to approve the right to clean water, because this is beyond a doubt something the citizens of Brevard County want. Thank you.
Thanks for your time, sir. All right. Lou Kontnick? Thank you, sir. Welcome.
Thank you all. Lou Kontnick, I live here in Brevard, and I support the inclusion of the right to clean and healthy water in our charter. Here's an example of how it might be used. We probably all remember back in the spring of 2018, we started to hear that Blue Cypress Lake was experiencing an algae bloom. The blue-green algae grew and grew until we had a serious health situation on the Class 1 headwaters of the St. John River, the source of our drinking water in Lake Washington. T.C. Palm and other media were covering the problem and even tracing it directly to the excessive dumping of partially treated human waste, biosolids they call it, on Presley Ranch. It took months for DEP to investigate and finally act in its July 12th letter, halting, at least temporarily, the dumping. DEP reported that microcystin levels in the lake were 4,700 parts per billion, more than 47,000% more than the toxic level of 10 parts per billion. Their action was good, but very late, and after much damage was done. Dumping some of the 5,000 dry tons per year, 5,000 dry tons per year of dry poop began in 2012 after the legislature prohibited this dumping in South Florida. The Indian River County disposed of their waste in landfills, but the legislature prompted the dumping of South Florida's poop in Indian River. H&H Liquid Storage Disposal was paid more than $1 million in 2017 to dump 5,277 tons on the Presley Ranch adjacent to the lagoon. Observers had reported that the water was pooling in this dumped material months before the algae bloom began. We knew our very drinking water was being contaminated, but there was no path to address the growing issue. What Mike just said, legalized harm, was underway. Withstanding, if I could have a, withstanding to seek equitable relief under this provision, the observers of the pooling water or others seeing the endless stream of trucks full of poop headed to the ranch could have raised this issue and could have protected the drinking water before it became toxic. It's worth doing.
Thank you for your time, sir.
Thanks.
Any questions? Thank you very much.
I have a question.
Was that the last speaker on this
No, we've
issue?
got
Okay.
about six more.
I'll wait until they're all.
Okay, thank you. Laurel Lee Thompson?
Hi,
Welcome.
and thanks for all the hours that you guys are sitting up here doing all this work. This is the first time I've been to the charter meetings, and so I appreciate what you're doing. I didn't realize it was this involved, and so many of you. So good. So I'm Laura Lee Thompson. I live at 3550 Irwin Avenue in Mims. And in my lifetime, I've watched the Indian River Lagoon go from its status as one of our nation's most commercially productive estuaries that supported hundreds of fishing families to a lifeless water body that's best known now for the starvation deaths of more than 600 of Florida's iconic manatees. Its commercial fishing industry has evaporated. Once known as the redfish capital of the world, numerous annual fishing tournaments were held, generating millions of dollars for our hotel and restaurant industries, as well as our bait and tackle shops and a lot of other small businesses. The Indian River Lagoon was a popular subject for television's celebrity fishing guides and tourism travelogues. Today, many of our recreational guides have relocated to Texas and Louisiana, where they can easily find fish for their clients. Nearly 40 years ago, my parents started a seafood restaurant in Titusville that had a menu based primarily on local seafood products that were harvested from the Indian River. Today, we serve nothing from its once prolific waters. The condition of the river is a threat to multi-millions of dollars in real estate, a $2 billion a year tourism industry, the county's ability to attract new businesses, and our own health. The river can't speak for itself. I'm asking you to please give the citizens of our county the opportunity to decide if they will give the river a voice. Thank you.
Thank you, Ms. Thompson. See no questions. Maureen Roop. Welcome.
Hi.
Hi.
I know how you all feel. But this is nonpartisan. Did any of you see the Marine Council report card? Total health score of the lagoon failed. Habitat health score failed. The state's monitoring is not adequate. The FDEP department does not require testing of sewage spills, stormwater runoff, wastewater pollution, herbicides, pesticides. The IRL is collapsing. Marine animals are in dire straits. We have manatees dying by the thousand. The state, county, and cities still do not know why the seagrass is dying. And all the technology we have. Avian flu is prevalent on Kennedy Space Center and other parts of Brevard. Clean water is crucial to every animal on Earth, including us. I cannot, but all the times I have stood at this dais and other places on issues and requests, I cannot believe we are here begging for clean, unpolluted water. Please vote to send this to ballot and let the people decide. This is a non-partisan issue, and I think politics is not a factor because nothing can be politically right if it's morally wrong. Thank you.
Thank you, Ms. Roop. Next, we have Stan Johnston. Mr. Johnston, welcome back.
Stan Johnson, I'm just going to say ditto to what has been said, so thank you very much.
Thank you, sir. All right, next we have Sandra Sullivan. Sandra, welcome back.
Good afternoon, Sandra Sullivan. So I agree, this is a nonpartisan issue. MRC recently found our lagoon in Brevard County would be an F minus down from an F++, worse than the lagoon. I think universally everybody agrees pollution is causing the lagoon to decline. It's very concerning that the lagoon plan does not include pollution. The NEP and IRL Council, in the research I've done, requires our local lagoon plan to have pollution in it. And it actually goes so far to specify what pollution is required to be in there, including PFAS, organic phosphate pesticides, glyphosate, and some pharmaceutical chemicals. We have, as some of the previous speakers said, we have biocides coming up from South Florida, where some of the places that's coming from is in Miami, where they have a very high PFAS concentration in their biosolids muck, and that's coming up here into our waters. In addition, we're dredging the muck out of Grand Canal, which is over the cleanup target for both copper and arsenic. And we're taking and shipping that out to Platte Ranch. And we're putting it on the floodplains just south of our drinking water source. We've had 2 algae blooms this year on Lake Washington. It's not normal to have that in the wintertime. Arsenic is a phosphorus food for algae. So is it a coincidence that they're putting arsenic out on the floodplains? Oh, by the way, it's a Class A carcinogen. From the biosolids as well, just before COVID hit, we had 160 some odd cases of hepatitis A. These pathogens and diseases that is in biosolids going into our water sources, you hear about the flesh-eating bacteria and other things. This is a health and safety issue as much as it is an environmental issue. And it's also an economic issue because the lagoon is worth, more than $1 billion in economic stimulus across the lagoon. So I'm in favor of the right to clean water, and I hope that you will consider and put this on the language on the charter as a bipartisan interest item. Thank you.
Thank you, Ms. Sullivan. All right, that concludes the cards on proposal number 6. Mr. White, I think you had some comments you'd like to make?
Thank you, Mr. Chairman. I am extraordinarily sympathetic to this cause. I'm a native Floridian. I can remember very well what it was like to grow up in Florida when there were only like 5 million of us, right? I'm serious. I mean, the degradation that's been done to our lakes, to our rivers, our streams, our drinking water sources, it is clearly out of control. Many of you know, not enough, that I ran for governor and I stood in the Everglades and I said, we need to take the dedicated revenue source that is currently committed to purchasing additional millions and millions of property in the state of Florida, when already government owns over 30% of the state in some form or fashion, federal, state, or local. Over a third is already owned for the purpose of protecting environmentally sensitive lands. We ought to take 100% of that resource, that tax source, and we ought to convert it into cleaning up our waters. And of course, that fell on deaf ears, as I fully expected it would at the time. So I am absolutely, as I said, extraordinarily sympathetic to this issue. I don't have, though, any idea whatsoever for the attorneys in the room, what declaring it a right, the legality of that, and what the legal ramifications of that would be. So while I'm extraordinarily sympathetic, I keep using that term, I am concerned about the legal ramifications of it, and would really appreciate some input on that. Maybe Attorney Googleman can research that. Maybe you already have. And I missed a big part of the last meeting because I had to be out of town. So maybe I missed something in that regard. But I'd really like to have some input on that element of this issue before we conclude anything.
Sure. Thank you, Mr. White. Other comments? Mr. Jones?
Yes, sir, Mr. Chair. Thank you to Mr. Majak and everyone who came out to speak relative to this particular item. I was actually going to propose something very similar to this, considering having seen what Orange County passed, their charter commission passed, and the voters passed in November of 2020, protecting their waterways from pollution. I did actually speak to Mr. Majak on the phone and told him that I did have some concerns relative maybe to this particular item, but after doing some more due diligence, I no longer have those concerns. But that concern stemmed from Senate Bill 712 that was signed into law in June of 2020, which is the Clean Waterways Act, which potentially could have prohibited local governments from having grounds to sue. But I think the fundamental argument of Mr. Myjack's proposal is outlined in his third paragraph of his executive summary to us. And if you don't mind me reading that, it says, "The problem isn't a lack of strong environmental laws in Florida, nor is it due to a string of illegal pollution. The problem is systemic and more like death by 1,000 paper cuts, which is comprehensively difficult and expensive to remedy for large water bodies such as the Indian River Lagoon, much less to fully restore. To make sense of our hundreds of millions of dollars of taxpayer investment, we must be able to establish a stopgap, a do no more harm mandate, and allow individuals, businesses, and nonprofits to engage in the litigation to arrive at a better system." So with that, Mr. Myjack, thank you very much for bringing this item forward, and definitely looking forward to having some constructive dialogue as we move forward.
Sure. Ms. Jenkins.
I would also like to get from staff what the outcomes have been over in Orange County since they've implemented their charter amendment. What's occurred over there?
Okay, that'd be helpful. Thank you. Mr. Nye.
So I actually have I have similar concerns as to what's been expressed by Mr. White in terms of the ramifications of this, but I am intrigued by the the fact that we're trying to hold the governmental agencies responsible. And I have a hypothetical for the petitioner, Mr. Myjack. If I'm reading this correctly, if it could be shown that a particular policy in regards to a particular species of animal is actually a cause of harm to the lagoon, this would give Brevard County action against the federal entity that is driving that policy. Is that what I mean? Yeah, okay, cool, thanks.
Other comments? All right, well, we've concluded our comments on number 6, the right to clean water. That'll be, hearing number 2 will be at our next meeting. All right, next we move to Mr. Tredis' number 7 on repeal Article 8 and Section 8.1. Mr. Tredis?
Thank you. This would completely delete all words in Article 8, School Board of Brevard County, election of school board members, which makes elections by residence area. If you look at the Florida statutes, there's 2 ways that elections can be. First of all, the statutes start off with district-wide elections. That's the presumption that school board elections are district-wide, meaning every elector, every voter gets to vote in every school board race. And the only way by Florida statute that can be changed, 2 ways: by a vote of the school board to go to single-member residential area elections, and that vote places it on the ballot. The voters approve it, then it becomes by residence area school board elections. The second one is by petition, the same way. Enough petitions are obtained for single-member district elections by residence area, it goes to the ballot, it's voted on. There's no provision for charter amendment to provide for this. And this, I think, is a pretty clear example of the state of Florida preempting the counties from trying to establish residence area school board elections by charter amendment, because both cannot exist at the same time. It'll lead to inconsistent, conflicting results. Here's a hypothetical for Brevard County. My proposal is already submitted. It would repeal Article 8. Then I file another proposal which specifically says, and this is just a hypothetical, another proposal which says that we're going to change this charter to have district-wide elections. And then the school board next week votes to put on the ballot single-member residence areas elections. Let's say all 3 proposals pass. It's logically inconsistent, but voters can do what they want. So what that would result in is the electors saying we're going to have both in the charter district-wide elections, and because of the school board proposal, we're going to have single-member districts. So what's the supervisor of elections supposed to do on the ballot? Is it going to be single-member, or is it going to be district-wide? Because you have 2 conflicting parts of 2 conflicting votes. And I think it's a pretty clear example from that hypothetical of why this cannot coexist with state law. It's preempted by state law. It's not consistent with state law. And, you know, it also puts existing school board races, I think, subject to challenge, unfortunately. But, you know, I think the change needs to be made simply because it was wrongly done in whatever year this was done. I think it's somewhere in here, 1998. So for those reasons, I've made this proposal. Thank you.
Thank you. We have a couple cards. Katie Delaney. Welcome back.
Thank you. I just, I'll keep it short. I'm in support of this. Thank you.
Thank you. We have Sarah Mirsky. You agree?
I agree, yeah.
Okay.
Thank you. Thank you so much for your time again.
Yeah.
I come from Seminole County, and that's a county where you can elect school board members countywide, and you can recall school board members countywide. And just a couple comments about coming from one area with one school board and coming to another area with a different school board. What's really interesting is that the two differences that I've seen is that when you can elect each school board member countywide, there's more cooperation amongst the board and less politics. This current school board, there's way too many political divides on this current school board, and they really need to function to work together. And so that's why I'm in agreement with us as the county as a whole being able to elect school boards in each school board member in different districts, and also to be able to recall them. Thank you. Thank you so much.
All right. Any other comments on proposal number 7?
Mr. Chairman?
Yes, Mr. Jenkins.
Mr. Gugelman, do you believe that if someone were to challenge the current charter language about single-member districts for school boards, that there's a probability it would be overturned for not being permissible?
I think more likely than not, a court would rule that it's not been properly set up through our charter.
Also, could you find out what goes on in Seminole County, how they have recall?
Well, I don't know that they do, but I'll check it.
Mr. Tredis.
I've looked at the counties that have recall, and Seminole was not one of them. It probably has district-wide elections, but it didn't have recall. It was Sarasota County had recall, Jacksonville, and I think Columbia had a recall, but it was not Seminole.
Can we get that information? I mean, how did they do it?
You know, on the recall, it's interesting because it's so open-ended. It's just they can have a recall election. I think it was looking at 60 days. It didn't track the Florida statute at all, like mine does for county commissioners. But it's completely wide open. There's no grounds listed. They have the right to do it, and that's the way it is.
Okay, we'll get that official list. That'd be helpful.
Perhaps a more interesting question would be, in any of those counties, has there ever been a recall of a school board member?
Okay, let's find that out. That'd be great.
While we're asking for information,
Ms. Rosen, yeah.
I'd love to know how many. I understand there's legal ways to go about this. I'm curious how many counties in the state of Florida have single-member districts versus county-wide elections for their school board members, if anyone knows.
Mm-hmm. Any other questions? All right, that completes proposal number 7. We do not have any appearance cards beyond the speakers, so we'll take that up during the next agenda meeting. Okay, next we have Mr. Burns for vacancies and suspensions, section 2.7. Mr. Burns, welcome.
Thank you, Mr. Chair. And I'll try to keep this brief. It is, I think the proposal speaks for itself mostly, but a little bit of background. Last year, around July, we had a resignation in the city of Palm Bay where City Councilman Jeff Bailey unexpectedly resigned, which left a vacancy for that city council. The Palm Bay City Charter allows for the council to determine by ordinance how to fill their vacancies. That's the current language in there. I think they're trying to change that language now after the events that took place in July. At that time, the city council that was there decided to change the ordinance from a special election because of the time frame that was remaining for Councilman Bailey's term was less than a year. They decided that they wanted to appoint someone to that seat as opposed to having the special election. And the charter gave them the ability to do that. However, it was met with much resistance from the community, much resistance from members of the Republican Party. It met a lot of bipartisan resistance, for that matter. And as I put into the proposal, Mayor Medina was quoted on, television and during the meeting saying that he felt like the process of appointing someone to the council as opposed to a special election was un-American and unpatriotic. That sentiment was echoed by a lot of our leaders, both elected leaders and party leaders. One of the president of the Space Coast Young Republicans, for example, also spoke and echoed those same things. He took it a step further and said that if there was to be a special election, the public needs the opportunity to be able to hear who is running for those seats. They need to be able to get to know their candidates. One thing that I stated before on the other measure is consistency. I think that we have to have consistency in our government. We have to have consistency in our legislature. So the hundreds of people that showed up to the Palm Bay City Council to protest that appointment process have been completely silent in the process that is before us here at the County Commission today. We have a resignation of a county commissioner which has left a seat. The difference is that this charter says specifically that there will be an appointment. I don't know if those individuals who spoke said that their premise of appointments being unpatriotic, un-American, would still apply now in this instance. But I was also one of those people that spoke against appointing to the city council because I feel like the people should have representation that they have chosen. Unlike the city of Palm Bay, the city of Palm Bay members are elected at large. So if someone resigns or is deceased or whatever may have you, there's a vacancy, the citizens of Palm Bay still have representation because they've all chosen who have they picked on that seat. County Commission, that is not the case. It's a single member district. So right now in the second district, we have no representation. And much of the second district is unincorporated. So they do not even have representation at a municipality level. So their first step of elected government would be the state representative in their district. And I don't know, I would submit that most of the citizens don't even know they don't have a county commissioner in District 2 right now because there's no letter that went out, to all the residents. So what do we have? We have an opportunity to appoint someone. Well, the governor, I support the governor, but he doesn't live here. He doesn't know about the Brevard County residents. The people here need to have that same voice to pick who is going to represent them. And so we go from a democratic, transparent process of our elections, which we try so hard to protect, to now a non-transparent process where someone is being picked, and it might be someone who lost an election. It might be someone who the voters said that they didn't want. And at that same time, you have and I'm not trying to, pick on anyone, but the member that stated that he was against appointments is seeking an appointment, for the same position now, for a different position. So we go from saying it's unpatriotic and un-American to now I want it. So I'm looking for consistency. So I think that the way that we handle it is let the voters have their voice. 1 year is more than enough time to have a special election. We just did it in Palm Bay. One of the arguments against it was the cost. There was arguments that the cost has already been paid, through the sacrifices of our armed forces, through the many different ways that it's already been paid. So the cost is minimal. The cost is paid. I would submit, I think it was about $230,000 for Palm Bay to have their special election citywide, which is about 118,000 people, which is about how big the district would be for a county commission seat. Or you could say it would be 200 office chairs. I don't know. That's a bad joke. But my point is, I think that the appointments take away from the important democratic process of choosing who we want. And I think that the people who have been presented are probably would be great in the position. But the point is, our opinion doesn't matter in this case. It only matters of who the governor decides to put there. The other point is, if he decides to put someone there. So he can go as long as he wants to and not appoint anyone. So how is that fair to the members of that district to have had someone, they've chosen someone to represent them, that person has quit the position, and now they have no representation, and they have no way to make sure that they do have representation unless the governor decides that they do. So I feel like that is kind of against the whole principle of our democracy, and that's why I submitted my proposal.
Thank you, Mr. Ernst. Questions? All right, seeing no questions. Any other motions? Okay, with that, we'll go to proposal number 9. Was that timely filed? This is hearing number 0, right? Okay. You want to introduce that really quick? And just let people know what you're doing, and then decide if you want to keep on doing it. But no, please go ahead and do that. And next time we'll take on the first hearing. Mr. Fisher, you're recognized.
Thank you, Mr. Chairman. I'm not asking to get rid of terms. A lot of the emails have kind of indicated that I was asking to get rid of terms, and that's not my goal at all. Even though I could argue that some of the constitutional officers don't have term limits. But I remember being elected in 2008, and what I remember about that, typically it takes a county commissioner about a year to 18 months to really understand what the job is about. I jotted down some things that after first being elected, I realized that I was now in charge of the budget office. I was now in charge of central services. I was now in charge of communication. I had to deal with county attorneys, and the county attorney worked for the county board of county commissioner. You had the county managers that you were responsible for. You had emergency management. You had fire rescue. You had housing and human services. You had human resources. You had information technology. All of a sudden, you were running libraries. People wanted to privatize that, and what did that mean? You had Merritt Island District Redevelopment Agency. You had mosquito control, natural resources, management, North NBES, Park and Recreation, Planning Department, Development, Public Safety, Public Works, Solid Waste, Tourism, responsible for all of that, Transit Services, Utility Services, Vicaria. You had also deal with the constitutional officers and handle their budget, and then you had all kind of special districts. If you think you can learn that real quick, it's hard, and you wake up and you're 2 or 3 years into your term trying to figure out what this job's all about. And then doing that process, you start building your network of friends and benefit, trying to get that network and relationships going where you know how to move things forward and get things done for your constituents. And most times in the end of 4 years, for example, what I found is that if you get up for re-election and you you start a term, most commissioners start with a new staff because most of the other staff had gone, so you don't really have any experience in that office. And so I just think that it makes some sense, having served in that spot, that it can make some sense to allow commissioners to serve 3 terms and have discussion about it.
Well, thank you, Mr. Fisher. We're going to take that agenda item up next week, or next meeting, excuse me. And so we're down to 7 proposals at this point. There might be an adjustment on one of the ones we removed today. We still have a couple items still. We have new business. Mr. Tredis, you have a motion for Mr. Googleman, I believe, on new business?
Yes, the motion is in writing in the agenda. It's a motion for Commissioner Attorney Paul Googleman to seek Attorney General opinion from Florida Attorney General Ashley Moody on whether the proposal of amend Brevard County Charter to add recall school board members is violative of Article 8, Section G of the Florida Constitution.
All right, do we have a second for that motion?
Second.
All right, seconded. Any objection to that? Okay, Mr. Googleman, you are commissioned to work on that, my friend.
Mr. Chairman, just I'd like to collaborate if I can with Mr. Tredis. I think his motion is well taken.
Okay, that objection?
Yes.
All right, we are on the final section, which is public comment. We have a few cards. Mr. Johnston, I believe, has left the building, so he is
Can we make
Ms.
sure of that,
Sullivan?
Mr. Chair?
Ms. Sullivan, I don't believe is here either. I think she's left as well. Ms. Bursky, did you have a comment you'd like to make? You'll back time, okay. Ms. Delaney? Okay, great. Okay, we have reached the end of our agenda items. Are any other items that want to be brought up? Ms. Rogerson?
Yeah, just to give everyone on the commission a heads up, I have submitted, I will be working with Melissa to get it in the proper format, and not to everybody, but a proposal to change the majority that is required by voters to pass a charter amendment to a supermajority. If we have to live by it, I think consistency is important, as has been stated, so my proposal will come forth next.
And is that a supermajority, 2/3 or 3/5?
60%.
Okay, thank you. Mr. Tredis?
You know, I think a good point was made today about the website not informing people, you know, particularly how their proposal might have a chance of better succeeding. And I think it would be a good idea if the county website were to say something to the effect that it is recommended that proposals have be in the language that they would appear on the ballot, and also the language that would be added to the charter be underlined, any words in the charter deleted, stricken through, just because, you know, people have made a point that without that, they don't know what to do, and we're sort of, I think, of the opinion that that's really important. So I would make a motion that that be added to the language of the website.
All right, do we have a second on that? Okay, that's second. Any objection to that being added, Ms. Jenkins?
That not everybody's got that skill set. It should be optional.
Yeah, I said recommended. I mean, I'm not saying it's mandatory, but the language is recommended that this be done.
Okay, without objection, we'll show that done. Mr. Luker, do you have? Okay.
Yeah, real quick, just since we changed the timeline a little bit, Paul, I think that may impact the legal opinion I need from you on 5.2 related to 4.2, because I'll be on the record, I'm a very strong proponent of recall for everybody, and if the language doesn't say that those officers are subject to recall, then I'm going to bring that forward.
Mr. White?
Yeah, I just wanted to say generally, Mr. Chairman, I know this ain't your first rodeo, and you've faced plenty of hostility throughout your career, but I thought you did a very good job today. I thought it was remarkably fair, and you handled the controversy very well. So thank you very much for that.
Thank you. That is very generous of you. Thank you.
And
Yes.
just one thing, so since everybody volunteered and threw up their hands about doing that potential proposal, no, all kidding aside, just an FYI, I am going to work on drafting something short and sweet that, in the off chance that Mr. Tredis's proposal doesn't pass, the three-panel attorney group will actually have to revert back to us to allow us an opportunity to cure it within a certain amount of time. So I'll work on that language. If nobody has an objection, I'd like to consult with Mr. Googleman on that. And
I'll second that. Without objection, we'll show that done as well. Other, for the good of the order. Well, I appreciate the kind words, Mr. White and others, and I appreciate the decorum everyone showed. I mean, this can get stressful, and I think everyone's shown a real professional attitude. And as we go through the next couple months together, get a little hot and heavy. It's nice to have such a cool, collected group that we're all working with together. And we'll look forward to reading those proposals. And without objection, Mr. Fisher moves you rise. Thank you.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.